Ready? Good morning and welcome all. It is now 1 minute past 10 a.m. and I would like to formally open this specific issue hearing 5 for the Mooir Vannin Offshore Wind Farm project. Before introducing ourselves, I'll cover off housekeeping. Can everyone in the room hear me right at the back? Yeah. Mr. Randall, have live streaming and recording commenced? Okay, yes, they have. Everyone present in the room, if you could please set all devices and phones to silent. Toilets are to my right through the double doors. There was a planned fire drill this morning, but there aren't any more. So if there is a fire alarm, please leave the building by the nearest fire exit and collect in the car park. On to panel introductions. My name is Ms. Sahai. I have been appointed under Section 27 of the Marine Infrastructure Management Act 2016, or MEMA for short, to chair the panel of examiners for this application. Together we are known as the examining body. I confirm that I've made a conflict of interest declaration as part of my appointment, and for avoidance of doubt, confirm that I've not had any professional or contractual engagement with Ørsted, the applicant, the Department of Infrastructure, or any other department or agency in the territory of the Isle of Man. For context, I've been an examining inspector and chaired examining bodies such as these in relation to nationally significant infrastructure projects promoted across the UK from 2016 to 2024, where I've discharged my duties to examine those projects with openness, fairness, and impartiality. In the conduct of a thorough and fair examination for this application, all parties are free to raise the merits or disbenefits of the application. As we are still in examination, we have not made any determination on the merits and disbenefits. After the close of the examination, we will take all submissions and evidence into account for the purpose of our recommendation to the Council of Ministers, and Council of Ministers will make the final decision. I'm a chartered member of the Royal Town Planning Institute, which means that I'm bound by their Code of Professional Conduct, which sets out ethical standards for all members of the Institute to meet, including the requirement to operate with honesty and integrity and to exercise independent professional judgment. This underpins my commitment to conduct these proceedings in a manner that's independent and procedurally fair to all. I will now hand over to my fellow panel members to introduce themselves. Ms. Fernandez.
Morning, everybody. Nice to see the sun coming up after a slightly gloomy start. My name is Frances Fernandez, and I am a panel member appointed pursuant to Section 27 of MEMA. I confirm that I have made a conflict of interest declaration as part of my appointment, and for the avoidance of doubt, confirm that I have not had any professional or contractual engagement with Ørsted, the applicant, the Department of Infrastructure, or any other department or agency in the territory of the Isle of Man.
Good morning, everybody. I'm Ms. Pownall. I'm a panel member appointed pursuant to Section 27 of MEMA. I confirm that I have made a conflict of interest declaration as part of my appointment, and for the avoidance of doubt, I confirm I do not currently, and since my appointment, have not had any professional involvement with Ørsted or the DOI or any other Isle of Man department, agency or business. For context, over the last 35 years, I have been integrally involved in consenting, application and construction of major infrastructure projects across the UK and overseas. I'm also a chartered member of the TARP TPI, which means I am bound by a code of professional conduct in the same manner as it does the other panel members, and frames my conduct for this examination.
Good morning, everybody. My name is Mr. Smith, and I too am a panel member appointed pursuant to Section 27 of MEMA. I confirm that I too have made a conflict of interest declaration as part of my appointment, and for the avoidance of doubt, also confirm that I have not had any professional involvement with Ørsted or the DOI or any other Isle of Man government, department, agency or business. For context, I have been an examining inspector in relation to nationally significant infrastructure projects across the United Kingdom. I served as the head of profession for planning inspectors in England and Wales from 2008 to 2012. I served as the equivalent to an examining inspector for infrastructure in the state of Victoria, Australia from 1999 to 2005. I too am a chartered member of the Royal Town Planning Institute, the RTPI, which means that per my colleagues' declarations, I am also bound by their Code of Professional Conduct, which applies to me and also frames my conduct in this examination.
And just for completeness, I have been an examining inspector in relation to nationally significant infrastructure projects across the UK. I am a fellow of the Royal Town Planning Institute, which means, as the same as my colleagues, I'm bound by the Code of Professional Conduct, which sets out ethical standards for all members of the Institute. And I operate professionally within the same professional and ethical framework as my colleagues on the panel. Thank you.
Also present are members of the Cabinet Office case team, notably Mr. Tom Randall, who provides procedural support throughout the examination process. Audiovisual service is provided by Energy Media Limited. We will go through our introductions before taking any questions. Thank you. Just a few words about the format of this hearing. The use of personal information and the general conduct of proceedings before I hand over to Ms. Fernandez to lead the rest of the topics. Today's meeting is being undertaken in a hybrid way, meaning some of you are present with us at the venue and some of you are joining us virtually using Microsoft Teams. Some have chosen to watch the live stream, and additionally a recording of today's meeting will be available on the MEMA website as soon as practicable after the meeting has finished. With this in mind, please ensure that you speak clearly into a microphone, stating your name and the organisation that you represent, if relevant, each time before you speak. If you're not at a table with a microphone, there are roving microphones, so please wait for one of these to be brought to you before you start speaking. Just a few words about personal information. When speaking, do think carefully about your personal information. If you feel a need to refer to something of a personal or confidential nature, please remember that anything that you do say will be included in the published recording. The Cabinet Office is administering the consenting process for applications made under MEMA, and in that regard, it will process personal data in accordance with the Data Protection Act 2018 and GDPR and LED Implementing Regulation 2018. Further information relating to data protection can be found in the Cabinet Office's privacy notice. This was provided in our Regulation 32 letter of the 6th of February. But if you do have any questions, please speak with Mr. Randall. Just a few words about the statutory framework of the hearing. Under Section 31 of MEMA and Regulation 31 and 34 of the Marine Infrastructure Consenting Process Regulations 2024, the examining body can hold specific issue hearings if we think it is necessary to ensure that a particular issue is examined properly and that principal stakeholders have an adequate opportunity to state their case. The examination under MEMA is an inquisitorial process, and it is for the examining body to lead the questioning in order to test the evidence before us. For the purpose of this hearing, we will not allow cross-questioning between parties. If parties consider that further points need to be explored, they should indicate this to the examining body, and we will decide whether those matters should be pursued. While we pursue some of your questions at the hearing today, some might be explored later through written responses from the applicant. Now, today's hearing is specific issue hearing 5 on landscape and visual impact assessment and will be led by Ms. Fernandez. I will hand over to her now.
Okay, so delighted that you've all come along today, and just let me set out the purpose of today and then I will take introductions. So we have 5 main items on the agenda. Item 3 will be chewing over policy matters relating to the Isle of Man strategic plan and the National Policy Statement framework. And item 3B, which we have as landscape character assessment, I'm going to combine and consider that alongside item 4D, candidate special landscapes, which we'll hopefully get to later this morning. Item 4, we'll be looking at the seascape effects in the Isle of Man onshore. And then we were turning to landfall and coastal processes at item 5, looking at some of the control documents, management plans, and how the proposed landfall location would be constructed. So hopefully that gives us a sense of where we're going today. Just again for context, this is our first specific issue hearing into landscape visual impact assessment. We have already had a number of written questions, and thank you all for your responses. We've also received the local authority effects statement from GARF commissioners and from others, so that was extremely helpful. And this hearing is a natural continuation of our exploration of these topics. It won't be the last time we return to the matter of landscape and visual impact assessment, but it is our first hearing on the topic today. Okay, so let me now take a roll call of who's in the room and see whether our attendee list tallies with who I'm expecting to be here. So let me start with the applicants team, please. And Ms. Sterling, if you'd please introduce yourself and the team, that would be great.
Thank you. Good morning, Madam. My name is Amy Sterling. I'm a partner at Pinsent Masons and I'll be representing the applicant today. I'm joined on my right by Mr. Toby Yates, who's an associate at Pinsent Masons, who will also be representing the applicant. On my left is Mr. Simon Martin, who's a technical director at SLR Consulting and is our seascape, landscape and visual impact consultant. I'm also joined by members of the applicant team, Dr. Julian Carolan and Miss Hannah Turner-Roter, who may also speak at certain points.
Thank you all very much. And then may I turn please to the Cabinet Office.
Good morning. My name's Diane Brown. I'm the Head of Planning Policy for Cabinet Office.
Thank you. And DEFA?
Good morning. It's Ken Milne, representing DEFA. I'm also joined online by our technical expert, Oliver Brown. Thank you.
Oliver, would you just check that the audio is working and say hello, please? That'd be great.
Good morning. This is Oliver Brown. Hopefully you can hear me okay.
Yeah, that's great. Thank you, Oliver.
Thank you.
I'll refer to you as Mr. Brown. And then if I may turn to your colleagues to the right. Thank you. Sorry, colleagues to the right of Mr. Milne. You, yes.
We have Mr. Garden online for us, CMS for DOI, please.
Oh, okay. Good morning, Mr. Garden. You're going to introduce, it's always slightly confusing because you're online and your team are here. If you'd introduce yourself.
Apologies, madam. So Robert Garden, partner and solicitor with CMS, and we're representing the Department of Infrastructure. And you're joined in the room by Emma Rowan, who's the Senior Infrastructure Policy Officer for the department, and likely later today by Ian Brooks, who's the Legislation and Policy Manager. Thank you.
Thank you very much. Is Douglas City Council here? And I'm assuming from the three hands up that tallies with Dana Enyo, Chris Pycroft and Ian Jackson. Thank you. And GARF commissioners, are you here?
Good morning. I'm Rich Anthorn, I'm Chair of GARF.
Could you just wait for a microphone to be brought to you? But if it might be quicker, if you could just come up to the microphone. This is just for the recording. I know it can be inconvenient sometimes. Thank you.
Yeah. Good morning. Richard Henthorne, Chair of GARF Commissioners. I'm joined this morning by Mirinda Farragher, Commissioner, Jamie Smith, Commissioner, and also Martin Royal, who's our clerk. And just to explain our point of view and our position, we are unpaid volunteers, and we are not a technical background, and we're trying our best to keep up with the absolute plethora of information that's come to us and try to understand. So that's our position.
Thank you very much. And then I have a number of people that indicated that they would like to attend and to speak. And again, just to check that my records tally with the reality in the room, I understand that Alison Strafford had registered but is not here today. But Ian Strafford, you are here and are registered to speak. And I'm taking a hands up for the purpose of the audio to confirm that you are in the room. Anne Barks is not here, was registered to speak but is not here. And Martin Cubban is here. Thank you very much for indicating that. And Julia Crigeen is here but would not like to speak. And Julia Crigeen, for the purpose of the audio, says she's too upset to speak. Thank you. Sarah Wales is here. No, she's not here. Thank you. Julia Yates, and would like to speak. Thank you. You confirmed with your hand up. Michael Thierry, not here. No. And Michelle Cook is not here. No hands up. Thank you. Now, it's not clear to me which of the items you would like to speak. Ah, yes, Patricia Newton. Yes. Patricia Newton, I beg your pardon, has registered to speak and is in the room. Thank you. And is there anybody else that has registered to speak? Thank you. Can we just check?
My name is Pam Carouche.
Ah, yes, thank you. Apologies, I did have your name. Pam Carouche has indicated that she would like to speak. And anybody else? It's always a slight administrative challenge making sure that two lists work together. And of the people that have indicated they wish to speak, for the ability to manage the agenda, I am going to ask you which items you would like to speak to. So presumably you all have an agenda in front of you. I'm going to start at the top of my list. Mr. Strafford, which items, please? And the microphone is on the way to you.
Hi, good morning. Ian Strafford, resident of Laxey. You'll see on the agenda that there is a response that I put into the examining board, particularly around the planning policy test that was put in. Clearly, when we come to that point in the agenda, if necessary, I'd like to speak. I don't want to take up time if it's unnecessary, but depending on how that agenda item goes. And I would also like to reserve the right, if it is okay with the examining board, that if I hear things which jog my memory of something that is important that I've got, because there's a lot to be covered, that I'll put my hand up, and if it's appropriate, you'll allow me to speak. Thank you.
Yes, that would be helpful. Thank you. And Mr. Strafford, I was aware that you had your hand up earlier, and I just want to make sure that we don't lose the question that I think you were hoping to ask earlier.
Thank you very much, Ian Strafford, resident of Laxey. It was in relation, really, it's more about procedural hygiene. At the start of the meetings, as you've always done, you have declared your conflicts of interest, and I appreciate that. I just wanted to note that in January, Comin appointed technical advisors to the board. And one of those technical advisors, it would seem, has previously been employed by Ørsted on Hornsea 1, 2, 3 and 4. So I would like to understand whether or not the technical advisors to the board are also able to make such conflict of interest declarations, because I believe that is important to ensure the hygiene and that we are all confident that you are receiving unbiased information and technical advice. Thank you.
Thank you very much for that point. And because you've made that point at the hearing, it's probably best if we just make a very brief response to it. And this is a follow-up from, I believe, one of your submissions at deadline 3 as well. So if I'm not mistaken, the technical advisors that you're talking about are OWC. It's just worth highlighting for everyone that the legislation allows for the examining body to get technical expertise and technical input from assessors. They are not decision makers. The accountability for the recommendation rests with the examining body. Now, before the appointment of OWC specifically, the Cabinet Office undertook independence checks. And it is our understanding that OWC confirmed that they were able to act independently and that they are currently not providing support which would represent a conflict. More importantly, the individual assessors supporting the examining board have not worked for Ofsted. It's just worth stating one point that consultancy may historically have advised on other offshore wind projects. That in itself does not mean that they are conflicted out of the process or not suitable experts. And in fact, this is particularly in a specialist field like offshore wind, where relevant expertise will often come from people or organisations with sector experience. So, just to reiterate the point that the statutory responsibility for the examination remains with the examining body, and what we do with the assessor's advice, in fact, is a matter of judgment for the examining body. So in considering and acting on any such advice, we do so within the bounds of impartiality and independence, which we've already explained to you. So we will consider all submissions and evidence on their merits before making the recommendation to the Council of Ministers, no matter what the advice is from the assessor. So thank you for raising that point. It is important to get this point of procedural hygiene, as you've said, out of the way. Thank you. Back to you, Ms. Fernandez.
Okay, thank you. That's a very helpful point and important that we clarify these matters, so thank you. Okay, Martin Cubban. Which items, please, would you like to speak at? And I'm hoping the roving microphone will find you, and then you can be recorded. And I'm also hoping that my colleague, Mr. Smith, is taking track and will nudge me, metaphorically or virtually, to make sure I remember to pick you up.
Yes, thank you. I'd like to speak to item 4, onshore seascape effects in the Isle of Man.
Brill, thank you. And then Julia Yates.
Morning. I'd also like to speak number 4, onshore seascape, the effects for the Isle of Man.
Thank you. And Michelle Cook.
Michelle Cook, apologies, is not present.
Ms. Newton.
I would probably want to speak on 3, 4 and 5, but it depends. I don't want to repeat anything that other people say or repeat myself, so it would just depend how it goes.
Yeah, thank you. Ms. Karouche.
Thank you. Onshore seascape effects on the Isle of Man.
So, item 4, yeah. Okay, thank you. Have I missed anyone? Good. Okay, so let's turn now to item 3. This is about the planning policy. And in this item, we're looking to explore the policy framework within which we are considering landscape visual impact assessment effects. So turning to the applicant, you stated in your planning support statement that the Isle of Man Strategic Plan 2016 is capable of being treated as important and relevant under section 36(4)(d) of MEMA 2016, and that the Council of Ministers must have regard to it when determining the MIC application. Further, you state that this is particularly important in the absence of a formal marine plan or marine policy statement in the Isle of Man. And you refer to Appendix 5, stating that until a dedicated planning policy statement is issued for EIA applications, the Department will adopt current practice from England and Wales, which the applicant relies upon to justify reference to the UK national policy statements and the UK marine policy statement throughout the planning support statement. So, do you agree that my summary is an accurate reflection of the position that you've set out in the planning support statement?
Amy Sterling on behalf of the applicant. Yes, that's correct.
Then, in terms of policy hierarchy, what is your view on the relative importance of the Isle of Man strategic plan and the NPS suite? Which policy framework takes precedence over the other in the event that there are differences in approach?
Amy Sterling on behalf of the applicant. The way that the Isle of Man strategic plan is framed is that the UK planning policy is relevant to the extent there is no Isle of Man specific policy. So my view would be that where there is an Isle of Man specific policy, that has precedence. Of course, I would welcome the Isle of Man government's view on that.
And so, thank you for that. Cabinet Office, would you agree with the applicant's position in terms of the policy hierarchy, and in the event of differences, which policy framework would take precedence over the other?
Diane Brown on behalf of Cabinet Office. In terms of the reference there earlier to the planning policy statement, there has been no planning policy statement produced as was set out in the strategic plan. It's quite clear in the strategic plan that in the absence of planning policy on Ireland, then it's acceptable to look to the UK for advice and policy guidance. That has been the practice.
Can you then set out what is the Isle of Man strategic plan and how that would relate to the MPS suite in the situation where there are differences set out?
Well, I think that's for the in terms of on-island planning. That's down to the decision maker looking at the planning applications and weighing up the evidence that's before them.
And so just to repeat what I think I'm hearing from the Cabinet Office, in your view, it is for the decision maker to determine the relative weight and the hierarchy between, for example, the Isle of Man strategic plan and the national policy statement.
Diane Brown on behalf of Plan and Policy. Yes, the Town and Country Planning Act 1999 sets out what the decision makers must take into account, and that's and there's a list in section 10.4 of what can be taken into account, and that includes the development plan, any planning policy statements, any other material considerations. So it's very much in the hands of the decision maker as to weighing up those elements.
Do any of my colleagues wish to come in at this point?
If I could briefly, Ms. Fernandez, I mean, I just want to test the effect of that advice, Ms. Brown, from Cabinet Office, because in effect there, the Cabinet Office position is that the examining body will need to review the balance of policy, looking at the degree to which there is first applicable in Ireland policy, that if there is not, that it should then step down the staircase to the next level, which is to look at the degree to which there is applicable UK relevant policy, But at the end of the day, we will then need to articulate the way that we have treated policy in a recommendation form, because it will be for the final decision maker, Council of Ministers, then to agree or to disagree, firstly with the proposition around the applicable policy and its relative weights, and then secondly with the consequential decision, which is how to treat the application within the framework. Am I correct if I set things out in that stepwise form?
Diane Brown on behalf of Planning Policy. I think that's a very good summary. Obviously, I'm speaking on behalf of Cabinet Office Planning Policy and not from a development management point of view in DEFA. Thank you.
And I do take that as said, but at the end of the day, our practical purpose here, at the end, there are some quite critically important policy tests that bear on the subject matter that Ms Fernandez will be examining today, where above all, we must avoid bear traps. And we therefore need to have heard and taken on board the broadest range of views, and critically the view of government as the owner of the policy framework, to make sure that we produce our best effort in framing a recommendation report that is A, fully compliant with your understanding of the legal and policy framework, and B, can be used by the decision makers as best possible. So, yeah, with all of those caveats, are you reasonably content that our understanding is correct?
Yes, sir.
Thank you very much.
And so, I will come back to it. I think what's going to be helpful here is if we ask the applicant, and I'm sure it's in the documentation, to produce a table by topic with what you consider to be the primary relevant policy and subsequent policies relating to that topic. And as I say, it will be there, but if we can bring that together. And that would be a deadline for action. And then my request would be for the Cabinet Office to review that and to see whether the Cabinet Office would agree with that approach. I think that would be helpful for us.
Could I just follow up on that, if that's all right, please? So this is principally for Environment and Policy 4 that we'll be dealing with tomorrow. But I just wanted to refer to the Cabinet Office and DEFA's response on Policy 4 and the relevance of the strategic plan to offshore development, if that's all right. So the Cabinet Office at, D1132 said, the extent of the Town and Country Planning Act 1990 exceeds to the mean low water, but as discussed in the hearing, there is a mention of marine reserves. My interpretation is that the intention of the policy was to protect any such reserves from onshore development proposals that would have an offshore impact and affect those particularly sensitive areas. So the implication there is that the strategic plan is for onshore development rather than offshore development. And then DEFA, in their response, D1133, says the Isle of Man Strategic Plan 2016 was developed for Town and Country Planning Act, and as such does not apply to developments consented under MEMA 2016. However, the principles of the plan may be relevant in the absence of equivalent marine policies as they reflect the thinking and intent in relation to development affecting habitats and protected species. So does that same principle apply here? There's obviously a difference in view between DEFA and the Cabinet Office, but does the principle of offshore development and onshore strategic plan policies apply?
Diane Brown on behalf of Cabinet Office. I think this was a question that came up at one of the previous hearings for Environment Policy 4. It was the policy in that particular instance refers to any development on land that may well affect sort of the sea, the sort of. So I can't speak for what DEFA has set out, but from planning policy point of view, that's how I would interpret that policy. It was for onshore development that may have an impact offshore.
So in relation to the landscape policies, is that the same principle? Or does the landscape policies also apply to offshore development?
It's in terms of, I mean, obviously the strategic plan policies don't sort of extend planning control into the territorial sea. If you're almost thinking about it as a receptor, you're on land, and any development offshore is going to have an effect. So I think when the strategic plan originally came along, there was no the framework for that was not really thinking about potentially offshore. But when you read that policy now, it's you, as a receptor on land, you can take into account sort of development that's outside the planning boundary almost. So that's all I can say at this point on that.
Thank you, Ms. Brown. Just if I can just test that point a little bit more. Let's just take it one step at a time. So in the absence of a marine plan, it is for the examining body to determine what is relevant and important. Given the point that you've just made, that while the development is offshore, the receptors are primarily onshore in terms of landscape and visual and a few other environmental adverse effects. And therefore, it is up to the examining body to determine what weight it attaches to some of these strategic policies, which in fact do provide protection for receptors onshore for effects that might be arising from any development, essentially.
Diane Brown on behalf of Planning Policy. Yes, I think that's a reasonable approach to take.
Okay, so I think this is one where we are being ever so slightly coy in terms of saying what we think technically is what's allowable in terms of policy terms. What I think might help the examining body is if we could have some assessment, which is in your professional view as policymakers for the Isle of Man, is an assessment of how you would apply that judgment from a competent authority's point of view, competent authority being the Council of Ministers, and the examining body's point of view who are making the recommendation. In the absence of a marine plan, that sort of weight that can be applied to policies. Now, the applicant has given its view in its planning policy statement, and I am going to pick up some of those matters at SI87, but I think that a corresponding assessment of policies that Ms. Fernandez has asked from the applicant, similar view from you, would be helpful. I think that's it.
So is that an action at deadline 4? So just for clarity, any action that we refer to today will be deadline 4 unless we say something specifically afterwards, and for the benefit of doubt, deadline 4 is 16th of June. Okay, so let me dig about in this a little bit deeper, if I may. I'm particularly looking at Environment Policy 2 of the strategic plan. And this seems to be the most pertinent in relation to landscape and visual impact assessment. Environment Policy 2 refers to landscape and coastal value. It refers to the primary policy covering areas of high landscape or coastal value and scenic significance. It states that within these areas, protection of landscape character is the most important consideration unless either A, the development would not harm the character and quality of the landscape, or B, the location for the development is essential. And Ms. Sterling, in the application you contend that A, of environment policy, avoiding harm, cannot be met, and that the proposed development would result in some harm to the character and quality of the landscape and seascape experienced from parts of the AHLV along the eastern seaboard of the Isle of Man, and that this harm cannot be avoided or prevented whilst retaining the operability of the development. I wonder if you would just set out your thinking behind that in relation to A, just summarise your views on that. I think as it's such a critical part of what you are putting forward to us.
Amy Sterling, on behalf of the applicant, yes, this is driven by the outputs of the Seascape Landscape and Visual Impact Assessment and the significant conclusions reached. So I will pass to Mr. Simon Martin, who can summarise those, particularly in the context of areas of high landscape value, because there has been some subsequent clarification on the location and status of those from DEFA at the most recent deadline as well.
Good morning, Simon Martin for the applicant. So just to pick up on that point, we essentially took a kind of character-based approach in the assessment in the SLVIA and EIS Chapter 8. That's at 53. So that was in line with the Isle of Man policy context. So factoring in key characteristics and the sensitivity of the landscape that's identified within the associated landscape character areas within the AHLV, as well as those outside of that landscape. So we've considered as part of those assessments of effects on seascape and landscape character areas, so we've focused on those areas within the AHLV, which covers obviously much of the coastal landscape of the island and recognises its scenic significance. But the lack of, I suppose, defined qualities and purpose of the AHLV designation in itself makes it difficult to assess it in its own right in the SLVA, and we followed more the kind of local approach of the landscape character areas that are identified within the area of the east and area of the south local plans, and looked at kind of the assessment of key characteristics and qualities of those landscapes. So I think it was just to make that point that we've looked particularly at those local policies that are relevant and applicable to each landscape character area. So the policy for each of those landscape character areas can be judged through the consideration of the impacts on each landscape character area along the coast or seascape character area. We, in undertaking that assessment, have found significant effects on character and qualities of the coastal landscape. And as such, there is recognition in terms of the Environment Policy 2, in terms of the character and quality of that landscape, that I suppose due to the findings of significant effects on a number of those character areas within the AHLV, that there would be harm to the character and quality. So essentially in terms of that first limb, Part A of Environmental Policy 2, that it's not possible to avoid harm, so that's not met. We've gone on to look at the second limb of the policy as well, because it's a sort of an and/or
policy. So I'm just asking about the first part of that, which is A. And so to summarise, the assessment looked at AHLVs, and we're going to look at in item 4D the designations, because some of these seem to apply in parts of the East Coast and some of them don't, but I don't want to necessarily get into that just at the moment, so I want to hold that over. But effectively, your assessment led you to the view that there are significant effects and therefore Part A of that policy is not met. Is that a fair summary?
Yes, Simon Martin for the applicant. Yes, that's correct, yeah.
And DEFA, is there anything you want to say in response to that, particularly on Environment Policy A?
I think, Ken Milne from DEFA, representing DEFA. I think the Cabinet Office, Ms Brown, answered it, and she said where there is no marine policy, then the terrestrial one is the appropriate one to use. So we would stand by that.
And would you in any way disagree with the conclusion of the applicant in relation to Environment Policy 2A?
Ken Milne, representing DEFA. Yes, we would agree that such a large development would have a significant effect on the landscape.
So then let's turn to the second limb, as you refer to it, of Environment Policy 2B, that the location of the development is essential. And the applicant sets out in Planning Policy Support Statement that in its view, Part B is satisfied and that the location is essential. Would you please, again, this is such a critical policy, set out your views in relation to Environment Policy 2B, please, Ms Sterling.
Amy Sterling on behalf of the applicant. Yes, of course, ma'am. The Isle of Man government's policy spanning since the early 2010s is to deliver an offshore wind farm in Isle of Man territorial waters for export of electricity to the UK. I'm sure you would agree, Madam, it's not the role of this examination to examine the merits of that policy. That is the policy that the applicant is working to further. That is the purpose and the reason behind the MIC application. As part of that policy trajectory from the early 2010s, the Isle of Man launched an invitation to tender in 2014, where it set out locational guidance for applicants and respondents to that invitation to tender, which set a framework essentially for the bidding for the agreement for lease. The applicant, of course, also carried out its own technical, environmental and other constraints analysis to inform its bid. As recognised by the Isle of Man government, all applicants to that and respondents to that invitation to tender identified a similar location for development to the one that is currently proposed. The applicant, as a result of that invitation to tender process, was identified as preferred bidder, and ultimately an agreement for lease for the wind farm area, which is currently the subject of this application, albeit a slightly larger because it has been refined through the developable area approach, was awarded. The applicant, therefore, is bringing forward this MIC application in direct response to the Isle of Man government's policy. There are no other existing or proposed offshore wind farms in Isle of Man territorial waters to deliver that policy. There are no other agreement for lease. There are no other locations proposed. This location is essential.
Ms Sterling, I think you've ever so slightly scoped out the testing of that trajectory in terms of meeting that policy trajectory that you said that the Isle of Man government has since 2010. However, that policy about building offshore wind farm to export energy to the UK has not been tested. It hasn't been tested by a project before. So this is the first time that it's being tested in terms of a planning balance, in terms of how the adverse effects of a project trying to meet that policy need, what adverse effects that would have on the island. So, that is definitely a matter before the examining body and will be a matter before the decision makers as well. So I'd just like to get a comment on that, because it feels to me like you've, scoped out something which is definitely before the examining body.
Amy Sterling on behalf of the applicant. That's certainly not the intention. It is, of course, within the remit of the examining body and its recommendation and Council of Ministers to undertake a proper balancing exercise. What I would suggest is not within the scope of this examination to do is to set government policy, or indeed to consider whether developing an offshore wind farm in territorial waters is the right thing to do. That is the government policy. The government policy is to deliver an offshore wind farm in territorial waters and export the power to the UK, and I just think it's useful to make that clear. The proposed development should be considered, one, does it meet that policy, and two, in meeting that policy, does the benefits outweigh the harm? That's the proper planning balance, and we wouldn't be seeking to circumvent that.
That's understood, and it is the second point that I just wanted to reiterate to make sure that remains on the table, and that's understood by everyone in the room.
I'm going to turn to DEFRA in a minute, but I just wonder, Mr. Strafford, if this is very much related to representation that you made to us about Environment Policy 2 and the interpretation of essential. Would you like to say anything at this point? It is on item 3, and in which case we'll just ensure the microphone comes to you.
Ian Strafford, resident of Laxey. I've listened to the arguments and I understand the arguments that are being put forward, and I welcome the challenge which the Chair has just put in. The government having a policy does not by default determine that a project should succeed. The environmental policy number 2, if we are to agree that it is essential it goes there because that is the only area that has been identified as practical, then in that case that gives carte blanche to the developer to put in 1,000 wind turbines 1,000 metres tall, and it will still pass the policy test. That would seem to defy most people's logic, I would suggest. In terms of environmental policy number 2, let me just for 1 second draw an analogy. In Douglas there is a question about whether we should be developing a building site. It is the only site, has a building on it, it needs to be developed. It is essential, therefore that's where it is. Does that mean that that can be a 100-storey skyscraper? Would that pass planning policy? No, it wouldn't. So I do welcome your challenge, and I fundamentally disagree that the use of essential, particularly in light of the benefits to the Isle of Man and how those benefits could otherwise be achieved for the Isle of Man. So, as I say, the contention I have with this is that I do not believe that that assessment that's been made and the way it's been interpreted is a fair and honest reflection to the intent of planning policy number 2. Thank you.
Thank you, Mr. Strafford. Yes, I'll turn back to the applicant.
Amy Sterling on behalf of the applicant. I do think it is important for everyone to note that environmental policy 2 is just one policy to be weighed in the planning balance. The discussion is almost suggesting that environment policy 2 is a pass-fail for whether or not consent should be granted. That is, of course, not the aim of environmental policy 2. The applicant's position is that it does meet environmental policy 2 because it meets limb B of that environment, and that is something that should be properly taken into account in the planning balance, along with all other planning policies which may be relevant to the application, the merits and the disbenefits. I think it would be useful just at this point to pick up, to confirm the earlier action, because it's also on the agenda for Thursday, that in preparing for this hearing, the applicant also thought it would be useful to do another detailed update of the planning support statement, in particular to include these accordance type tables, because I think particularly with the clarification from the Cabinet Office today as to their view on hierarchy, that becomes ever more relevant. So we will undertake to do that for deadline 4.
Yes, that is an action that we were going to raise either today or Thursday, and so yes, we would like that very much. So Cabinet Office and DEFRA, I'm probably not quite sure where this would land between you, maybe both. What would your view be on the interpretation of Environment Policy 2 in relation to what we have been speaking about and what you've heard from Mr. Strafford and the applicant's response? Maybe it's more in DEFRA's camp. Well, I'm not sure. Maybe you should both have a view on this, I think.
Ken Milne, representing DEFRA. I'll start. I'll obviously pass over to my colleague from Cabinet Office. Put a little bit of history into this. Before the invitation to tender, there was a Manx Marine Environmental Assessment undertaken, looking at all the constraints in our waters, which helped to identify potential sites that may be suitable for development. And that was when the invitation to tender came in, and Ørsted selected the site that's currently being proposed. I don't think it's for us to comment any further on this, whether it's, we did that based on constraints in that marine environment, but obviously this is more linked to perhaps what the Cabinet Office could come in on.
Diane Brown on behalf of Planning Policy. In terms of Environment Policy 2, there was obviously sort of the first element to that, which talks about the areas of high landscape and scenic significance. I've probably said that wrong, but it is quite a difficult one. And then it goes on to talk about those two limbs, A and B. From a planning policy point of view, I'm here really to talk about like what is the framework that we're setting out. So the first part is to what I think we might come on to later is the Landscape Character Assessment 2025 and the implications and significance of that, and what that means to the certain areas that have taken those landscape character assessment areas into planning through the area plans. So in terms of assessment, there has to be, the first part is part A, which is about is there any harm, and then what's the assessment of that harm. In terms of essential, certainly there's no definition of what essential is, but that again is in the hands of the decision maker who's looking at potentially looking at alternatives. There may be other things that come into what is essential, but we don't. The policy itself doesn't go into any further description.
Okay, thank you. Applicant, did you want to come back on that? My colleagues. So, Mr. Garden online for the DOI.
Thank you, Madam. So, Robert Garden on behalf of the Department of Infrastructure. I think it's just important to clarify in this context that the site that is being promoted is the only site that is subject to an agreement for lease, and that there is no other proposed site and no other proposed leasing round, and important that you've got that context in terms of your consideration of this policy.
Yes, I'm going to be talking about the AFL in just a minute, but yes, thank you for that. Okay, let me turn then to Appendix 5 of the Isle of Man Strategic Plan, as I referred to briefly in my introduction. And this makes reference to the NPS and marine policy statements. And what I'd like to explore a little bit here is where there's a difference between Environment Policy 2 and NPS. What would be your thinking in terms of what the examining body might view as the weight to give to those different policies? So let me explain that in longhand. NPS 1, EN1, accepts that NSIPs, nationally significant infrastructure projects, at paragraph 5.10.5, will have a detrimental impact on the landscape. And I quote, virtually all nationally significant energy infrastructure projects will have adverse effects on the landscape, but there may also be beneficial landscape character impacts arising from mitigation. And at paragraph 5.10.12 of EN1, outside nationally designated areas, there are landscapes that may be highly valued locally, where a local development plan in England or a local development plan in Wales has policies based on landscape or waterscape character assessment. These should be paid particular attention. However, locally valued landscapes should not be used in themselves to refuse consent, as this may unduly restrict acceptable development. And then again at 5.10.13, all proposed energy infrastructure is likely to have visual effects from many receptors around proposed sites. And so if we take what MPSEM1 says, this is quite a difference to the Isle of Man Strategic Plan policy, where it states that protection of the character of the landscape will be the most important consideration. So the applicant, and then I will turn to Cabinet Office and DEFRA, and possibly DOI, given the wording of these two respective policy angles, what would your view be about how the examining body should give weight to EN1?
Amy Sterling, on behalf of the applicant, I think just to recap the position that we've got to is, for the purposes of MEMA 2016, there are no applicable policies within which the decision should be made. Therefore, it falls to the examining body and its recommendation and the Cabinet Office and its determination to consider what is relevant and important. The Isle of Man Strategic Plan is produced under the Town and Country Planning Act 1999, which is a terrestrial, it's part of the development plan for the terrestrial environment. It has no direct effect for MEMA purposes. Likewise, the national policy statements are, of course, prepared under the Planning Act 2008, which has no direct effect for MEMA. So we find ourselves in a situation where there's no directly applicable policy, and as you said, we have to then consider which is the most relevant. I would have suggested that the Isle of Man policy has primacy, because that is what the Isle of Man strategic plan says. It says that the UK planning policy will be used where there's unusual matters, novel I think is the word it uses, matters arise, or there's no planning policy to guide. But nevertheless, that is not as a matter of fact, because ultimately there is no planning policy under MEMA. So that's just a view. Nevertheless, I think the national policy statements are capable of being relevant and important, because they are more detailed, they're more well tested, and they are indeed designed for the marine environment, particularly National Policy Statement EN3, which specifically has policies, particularly on SLVIA, which apply to offshore wind farms, which of course the Isle of Man policy doesn't. I don't know if I could tell you right now what I think the weight should be between those. It's certainly something that we can review and comment on in our deadline for update to our planning support statement. I think there would probably have to be a balance between the two, because whilst the strategic plan is Isle of Man policy, it doesn't directly reflect the circumstances we find ourselves in, which the NPS does. And perhaps that's more of the novel element that the strategic plan is referring to when it talks about relying on. I hope I've not talked myself in circles, but I'm just trying to think through the hierarchy. But of course, I take the Cabinet Office's point that ultimately this will all be for the decision maker to decide, but that is perhaps not too helpful for you in making your recommendation report.
Sure, and as experienced inspectors, balancing things is sort of part of what we do. Nonetheless, it's helpful to have a indication of your train of thought. And so following that indication of train of thought, let me turn to my colleagues in the Cabinet Office. And actually I will ask DOI, Mr. Garden, and DEFRA as well for your views on this. And maybe we just end up back in the same place and we pass the buck, it seems slightly, to the examining board and ultimately the decision maker. But nonetheless, what is your view about those relative weights? And I'll turn to the Cabinet Office, then to DEFRA, and then I would like to ask DOI for a view.
Thank you, Diane Brown, on behalf of Planning Policy in Cabinet Office. I think it is always useful to consider what legislation, what guidance is elsewhere. We do have to be careful, and I think we've learned over the years that things don't always directly relate, and we have to be careful about just taking that guidance elsewhere as the dominant guidance. We should follow that. Sometimes things don't always translate, and I think, so in terms of the landscape character assessment that we've been working on and has been published last year, that did look to the guidance, National Park guidance on approach and methodology. So to say, that our landscape character areas, it doesn't translate well to the way that it's done in the UK, then you have to be careful making statements like that. So I think there is important guidance in the EN1. It's making sure that it's not brought carte blanche over to an Isle of Man context. Thank you.
Mr. Milne for DEFRA.
Yeah, Ken Milne, representing DEFRA. I don't think there's much more I can add. It's weighing it in the round and in balance that will no development weak the policies and achieve everything that's required? It's balancing it. I don't think I can add anything else. I'm sorry.
And Mr. Garden online.
Yeah, Robert Garden on behalf of the Department of Infrastructure. I'll start with the qualification in respect of obviously planning policy sits with the Cabinet Office and development management with DEFA. But I think the department's view is largely mirrors that of the applicant, that there is no directly applicable policy in terms of MEMA. So you then look to important and relevant considerations, of which the Isle of Man policy would have primacy in the first instance, but to the extent that there is a gap in policy, you would then look to UK policy and guidance to fill that gap. And I think in relation to the marine environment in particular, that's where the MPS has a particular role to play in terms of the assessment of this application.
Mr. Garden, I'm just going to backtrack a little bit and just go back, and I'm not really looking at that comparison between the environment policies and NPS, but I just want to go back to the environment policy 2B just for a moment, because your representation before this one, you did say that the agreement for lease, when that was determined, the location was basically established, and that is pretty much the only place. But my question is whether in determining the location for what would be leased, for what part of the seabed is going to be leased for this project, did you take into account environment policy 2B? Would any type of policy, strategic Manx policy, be relevant in determining the location of something which you can imagine at being a major infrastructure would have a massive adverse effect?
Robert Garden on behalf of the Department of Infrastructure. I think at that stage that there was not an assessment of planning policy. We can double check that, but the identification of the area was in pursuance of the island's objectives in terms of revenue generation through offshore wind, and did not go into a planning policy position, but happy to take that away and provide a written update if that would assist the examination.
Mr. Garden, just hold your thought. There's definitely an action, but I do want to flesh that out a little bit. So just bear with me one moment.
So just while that's happening, just let me recap the previous item. Applicant, you said you'd put your thoughts together on weight and hierarchy. And if I can just confirm that as an action for deadline 4, that would be good.
Ms. Fernandez, there's a little bit of thinking that we perhaps need to do as a panel before we issue that action. So if you could consider that over the break and then perhaps come back to you. So, Mr. Garden, there's definitely an action there, but we'd just like to flesh that out after we've processed this a little bit as an examining body. So bear with us. We will come back to this point after the break.
Sorry, I'm slightly confused in my mind there. It's okay. The first action, the applicant had previously said they would put together their thoughts around weight and environment policy 2, and I was confirming that as an action. And then Mr. Garden was talking about what was taken into account, whether environment policy 2 was taken into account at the time of the AFL, and Mr. Garden was taking an action to go away and talk to his colleagues to understand the position.
It's just around that action, Ms. Fernandez, what I was asking was for a little bit of time so that we as an examining body can just flesh out that action a little bit more. The second one, that's right. Yeah.
Thank you.
Amy Sterling on behalf of the applicant, if I may, just to inform that second action for Mr. Garden. I think as Defa mentioned earlier, there was a Manx Marine environmental assessment that was carried out and consulted on in late 2012 to inform marine planning within the Isle of Man. So it's not the case that, the AFL was awarded in a vacuum of environmental assessment. So we can certainly as well respond on that point. I appreciate the action isn't formalised yet. of course, it wouldn't have been Environment Policy 2 because the AFL award predates the Isle of Man strategic plan, so it wouldn't have been possible for it to consider it.
Yes, Mr. Milne mentioned that marine assessment, I think. Mr. Milne, has the marine assessment been submitted into examination? And the answer is probably no. In fact, I think I know the answer is no. And is it available, and can you please submit it in as an examination document?
That would be very helpful if you could do that. Thank you. As I understand it, though, the marine environmental assessment doesn't assess anything in particular. It just provides a baseline set of information for the marine environment on all the different aspects that includes. So it doesn't assess anything to do with the array or principles for the project to be based on. It's just baseline information. Could you just expand on that, please, DEFA?
That's correct. Ken Milne for DEFA, representing DEFA. As you said, ma'am, it's based on the existing marine constraints at the time. There has been a revision to the Manx Marine Environment Assessment after 2012, but again, it was just updating those existing known constraints on the marine environment.
Okay. Applicant, are you clear?
Amy Stirling on behalf of the applicant. Sort of. The Manx Marine Environmental Assessment, the most recent version in 2018, does have a whole section on offshore wind. Perhaps it doesn't balance offshore wind and the environmental policies. We can certainly review that and reflect on it. But there have, of course, been a whole host of other documents subsequently which have also considered the location and been consulted on, such as, for example, our island plan, albeit that obviously postdates the AFL. I guess it would be useful for the applicant, and this is perhaps what the panel need to reflect on, to understand the concern and what information we can provide to you to satisfy you, or provide some more information on the particular point that is arising in your mind, because I'm not entirely clear.
You know, it does sound to me like Mr. Milne and Ms. Stirling, you might well have a quick catch-up over coffee and agree that what is coming into us will give us a better understanding of what the marine assessment was and anything that's happened subsequently, which you probably both have a view on from slightly different angles. And then the action will be that we would like that information in, but we're going to talk about that over coffee. So we'll confirm the action, but would you just mind just talking to each other and check that between you, you're giving the examining body a full picture of what's happened? Thank you.
Amy Stirling on behalf of the applicant. We certainly can. We'll need to involve the Department of Infrastructure, who of course ran the AFL process, not DEFA.
Yeah, and I imagine DOI colleagues are in the room as well. Okay, so I'm going to look at item 3C of this agenda now. In fact, I'm going to ask my colleague, Ms. Sahai, to lead us through this, and we've had some very helpful representations that we've picked up in this item. Ms. Sahai.
So with 3C, what I'd like to pick up on is following on from the question that I placed before Mr. Garden just a few minutes ago, which is the agreement for lease. I think we found narrative around the agreement for lease from the applicant and from a few other parties in parts of the application and different representations, but we don't have a full picture. And what we are trying to understand here is the extent to which the evolution of the scheme, and in particular the increase in the generating capacity from the earlier 700 to 800 megawatts to the current 1.4 gigawatts proposal was in. And what we'd like to understand is to what extent this evolution was environmentally led and whether it was commercially led within certain environmental tolerances, if you understand the nuance between the two things. And this kind of goes back to the question that I was asking Mr. Garden. So I just hope the logic of some of this questioning is clear. But applicant, in your responses to written questions on the agreement of lease and the project evolution, you've explained that earlier assumptions were revisited because the AFL area could be more effectively utilised as turbine technology evolved, leading to a sustainably greater generating capacity within the same lease area. So the lease areas remain the same. You have referred to something called developable area approach. And you have said there, which balances environmental impacts, technical feasibility, and commercial aspirations. But what I'm unclear about is how you've done that and in what order, giving what weight. So what we're trying to understand in practical terms, how the adverse effects on the island, and specifically seascape landscape, because that's the hearing we're at, and visual impact materially constrained or indeed influenced the scale of the project which you ultimately have brought forward.
Amy Sterling on behalf of the applicant. Yes, the agreement for lease identified an option area within which the applicant was permitted to seek this MIC consent. That was originally assumed to be of a certain capacity. However, obviously the agreement for lease was entered into in 2015. As we sit here in 2026, 11 years later, turbine specifications have changed greatly, and it's therefore open to the applicant, and the applicant is able to make efficient use of the seabed and maximise the generating capacity by using the more modern technology types, therefore increasing the capacity of the site and ultimately the economic benefit to the Isle of Man, because that is related to the generating output, because that is how the lease structure operates. Within then the agreement for lease area, the applicant did not just submit an application for the entire red line boundary within the agreement for lease. It undertook what it calls the developable area approach to reduce that agreement for lease red line boundary to the red line boundary which is currently subject to the MIC application. The developable area approach was a three-stage approach, and I can pass to Dr. Carolan, who can explain in more detail if that would be useful.
Yes, Ms. Sterling, that will be useful, but do understand that what we're trying to understand is how you have overlaid environmental constraints in these steps. So these steps are roughly clear in my head, but how were environmental constraints, at what point were environmental constraints overlaid in your thinking when you determined the height of the turbines, the number of turbines, and the order limits within the agreement for lease area?
Amy Sterling on behalf of the applicant. Yes, that is the sole purpose of the developable area approach to what is an acceptable application, essentially. So I will pass to Dr. Carolan, who can walk you through the developable area approach, including the number of turbines, etc. Thanks.
Dr. Carolan on behalf of the applicant. The developable area approach is it's one of the key deliverables of our proportionate approach to EIA. And in the early stage, really, of the development, what we were trying to do was through I suppose the thing about the proportionate approach, is the use of the impacts register and the commitments register. So through the impacts register, we're trying to list out all of the impacts that will be associated with a project of this scale and this location. So we're listing out them all, and we're trying to figure out which of those in the early stages is pre-scoping, which ones would be likely significant to fact and come through into detailed assessment in the IA, and those that are of non-likely significant to fact that we can potentially screen out. We're looking then where we identify likely significant to fact to then bring forth early stage commitments, and those commitments can be primary, so they can be designs. We're trying to design out likely significant to fact at the very early stage of project development. So we bring forth those commitments, and then what we're seeking to do is to bring those things together on the high risk areas, so like for ornithology, SLVIA, shipping and navigation, fisheries, those key areas, and we're bringing together what we can at an early stage in the development, what we have on the impacts, on their spatial temporal extent, and how we then overlay them within GIS to refine the site.
Dr. Carolan, I'm just going to interrupt you there. You said there were several high-risk areas. You listed a few. Landscape and visual, I noticed, was not one of them.
No, it was.
Oh, my apologies.
Sorry. SLVIA, shipping and navigation, commercial fisheries. That's it, really. Yeah. And to a degree, ornithology. ornithology was a bigger issue on previous projects that we've had, not so much. So it was still a constraint that we give due consideration to, but it didn't really result in any array refinement. So the key ones that reduced array refinement here were shipping and navigation, fisheries, and SLVIA.
And just talk to us about the refinement that you made as a result of your considerations of the high risk that you've identified for the SLVIA.
These are all set out, the key design changes to the proposed development between scoping and application. They're described in the project description at APP 41 in section 2.2. There's a reduction in the size of the offshore array, and that reduction was approximately a 17% reduction in size, a reduction in the number of turbines from 100 turbines at scoping to 87 at application, so 13 turbine reduction. A reduction in the maximum size of the turbines, so from 389 down to 300. We reduced 389 blade tip height to 350. We reduced the rotor diameter from 320 to 296. And we reduced the number of offshore platforms from 5 down to 3.
So just in terms of, just so I understand this correctly, the 17% reduction in size, what did that tell you in terms of the adverse effect of the SLVIA? How did it in fact either mitigate or reduce that impact in your assessment?
I'll hand over to Simon to speak about the SLVIA component.
Yes, Simon Martin for the applicant. Just move that. Critically, in terms of those changes, obviously there's the change in the turbine height and the number of wind turbines, which are a big factor in terms of reducing seascape and visual. So obviously the reductions in turbine height and the number of turbines are a particular critical sort of consideration and factor in the refinements made. Probably the key things really were the spatial extent of the array area boundary relative to the AFL. So particularly reduction in the northwest corner of the array area, so the area that was kind of most visible from Mackled Heads and the Airs. So there was a reduction in that northwestern corner of the array from viewpoints, and an increase in distance from the coastline. There was also a reduction on the southern extent of the offshore array. So there was a particular, focus of visual receptors to the south around Douglas and more populated areas. The movement of the AFL area further north, the offshore array boundary, resulted in an increase in the distance away from the ferry routes, for example, and a reduction in the spread of the turbines, and also more separation from Morgan offshore wind farm.
Let me just pause you there a minute.
Could I just ask, so the reduction in the extent of the array, you've mentioned all the landscape, we are in the process of explaining the landscape issues. I just wanted to ask what proportion of the decision was for the reduction, particularly to the north, as a result of shipping and navigation, so a technical reduction that had to happen because of safety, in proportion to the reduction because of the landscape effect.
Bear with me, Dr. Carolan, just 1 second. Is it possible to get another microphone on the applicant's table? Okay. Let's test that during the break time.
Dr. Carolan on behalf of the applicant. Figure 11 of the site selection consideration of alternatives chapter basically sets out the spatial change in the project from scoping through to application. And in the northwest corner, that change in around the Bahama Bank, that reduction was made specifically, solely actually for SLVA to reduce the lateral spread of turbines. And then on the southern boundary, we basically had some change as well, and that was for the shipping routes, the fishing, the Queen Scallop area, and again to reduce the southern spread. So again, it was for three things. Primacy to the north was for SLVIA. On the southern extent that we cut off, it had three effects. It had three beneficial effects in terms of reducing likely significant effect.
Is it possible to get that? You mentioned the plan reference from the application.
Yeah,
Is it possible to get that on the screen? I'm not sure if that's possible. Just as you talk it through, it would be helpful.
I can, yeah, if we can do. Well, I don't know how to.
No, it's figure 11. Give us the application is of the
figure 11 in. It is in APP 042.
So while the case team are getting that on the screen, just as you're talking, it's helpful, I think, for everybody to just see the points that you're making.
I think there would be a few points. So just in terms of, you said that the change, the spatial change particularly at Bahama Bank was solely made for SLVIA. I think what will help not just the examining body but also other parties to understand is potentially a comparison between what you thought was the adverse effect and what a visualization of what that visual effect was, what it is now, and how you feel that that is a significant reduction in the adverse effect. It's still adverse, but how that is a reduction. Mr.
Dr. Kjorl, on behalf of the applicant, I think while there is some reduction, it's just impossible to design out adverse effects in relation to seascape, landscape, visual impact due to the nature of the development in close proximity. So any offshore wind farm, whether that was 1 turbine, 2 turbines, is going to have significant adverse effects. So it's not possible to totally eliminate it. So what we're trying to do is get the key principles in our developable area approach.
Yeah, I don't think, Dr. Carolan, with respect, that was actually the point that the examining body was driving at here. Essentially what we're trying to look at are the considerations that have been brought to bear on essentially your optioneering around effect in terms of SLVIA impacts. And there are trade-offs and balances that are struck. And what we're trying to look at is then in simple and representative visual terms what the effect of removing, for example, that northern triangle, if I can refer it as such, pointing up towards Bahama Bank was, and therefore what residual conclusion you then reached about SLVIA effect with that in the developable area as opposed to that not in the developable area. Now, that's not to say that you're going to be able to control or eliminate all such impacts. It's just looking at what the relativities between where you started and where you landed. Now, indicatively, a way you might have done that, or a way you might do it now to assist us, would be to produce just a very crude three-dimensional envelope that describes essentially zenith and the outer extent of the developable area as a three-dimensional polygon sitting on the water, and then essentially to compare what you see with that polygon in place in that northern triangle and with that polygon not in place in that northern triangle, so that there is then a very simple representation. I mean, this is not, in my view, something that requires detailed wireframes. It can be done on the basis of simple three-dimensional polygons. Similarly to the south, that you can look at a figure that then says, with respect of a key viewpoint from Douglas, and then in the north, in respect of a key viewpoint from Muckled Head, you're then very clear what the respective benefits in SLVIA terms were as you saw them, as you took them into account, as you stepped through your iterative design process. Does that help? Does that provide you with something that you might be able to do?
Dr. Garr, on behalf of the applicant, we have something to hand that probably would be much easier, and if acceptable, we can submit in. So we prepared wire lines and photo montages of the array at scoping stage. So for the full build out of the array, 100 turbines using the red line boundary. So we prepared them for our community consultation, and that's what we presented to people at the time. We then made the refinement based on the feedback from people during the consultation. We refined it down. So we have the wireframes as for the original full-scale development, if you want to call it that, at scoping, and then we have the other ones that support the application. And what we can do is we can show the difference between them, and then that would be probably more, it'd be a more useful tool than creating the 3D.
Absolutely.
Yeah, yeah.
I mean, I was somewhat reticent about asking for that on the proposition that you may not have that that degree of resolution in the assessment of your early stage design process. But if you've got it and you used it in community consultation, then absolutely, I think it would be really helpful to have it drawn to our attention.
Okay, so I've got many questions wanting to be asked at this point. So just to take us back, this is really understanding what was the design changes that were introduced at this point on SLVIA grounds, and what we're really trying to uncover is how much of this was actually driven from that point of view and how much of this was actually driven for other reasons, predominantly shipping and navigation. I would like to turn to Ms. Powner.
I just wanted to take a step back, if that's all right. So just so I understand the plan, which is quite simple. So the AFL, which is the area within which you're actually able to build, that's right, isn't it, for the entire audience? So that's the red, the AFL. Okay. So you then have to make the scheme, makes the wrong word, but the scheme has to be technically feasible for construction, safety, and all those considerations. So what I wanted to start with was, you had the first blue line boundary. So when you started to reduce it, what caused that in terms of shipping, navigation, safety, so the basic technical scheme? So if you've got another plan with a line that will be able to show that for us. So then, once you've got that safety technical scheme, you can then start looking at your landscape adjustments, because a proportion of that reduction has to be shipping and safety. So is that plan available? So then we can look at the difference between the basic scheme, which was safe, and what you reduced for landscape purposes. Does that make sense?
Dr. Carolyn, before you answer that, just to pull these 2 points together, what we are trying to determine is that how did you conclude that the present scale of development represented an acceptable or proportionate environmental trade-off in SLVIA terms? So at what point, you've said that we were never going to be able to take away the landscape adverse effects on the island. But what point did you say this much adverse effect is actually too much, but this much adverse effect is fine? So we're just trying to determine at what point did you feel it tipped the balance?
Amy Sterling, on behalf of the applicant, I'll take the first point first. I think it is important to note that site design is a holistic exercise, and for example, Dr. Caroline's pointed out that lower reduction in the south was for shipping and navigation, for fishing, and for seascape, landscape, and visual impact assessment. That's just good project planning. That's good project design. You're including 3 mitigations within the one area while still making efficient use of the seabed. In terms of the technical viability of the site, that obviously comes down to things like seabed conditions, etc. So I don't think it's the case that the applicant said, okay, now we've got a technically valid site, let's see what else, let's start taking bits off for SLVIA. It's considered in the round. So I'm not sure that that plan that you were looking for sort of exists or would be capable of being produced, other than to say, well, not the northern section.
I understand what you're saying, and the scheme is considered in the round, but a landscape and visual assessment assesses a scheme. Okay, you have a scheme which you consult on and you assess. Shipping and navigation has to be safe, and in your reports you've mentioned that the reductions were made for shipping and navigation purposes. So that's not part of mitigation, adjustment, landscape and visual. That is essential part of the base scheme. So it's just a simple question. From the original blue line boundary, or the original boundary you had, how much of it was reduced due to shipping and navigation and safety and technical reasons? So what was the baseline without the landscape assessment and the visual assessment on top and mitigation for that? I think it's a logical question. I think the panel would agree.
Dr. Keoghan, on behalf of the applicant, there is no real simple answer to it. I mean, I can explain. We've got multiple overlays of all of these things. So if within the site refinement annex, so within APP 071, which is the site selection, consideration of alternatives, and the refinement annex, it sets out the methodology that we applied, and that sets out the constraints, how they were mapped spatially, and then how they were all overlaid on each other. And what we're trying to do at all stages is to maximise the commercial advantage in the project while striking the balance with the environmental capacity of the site. Where there's significant overlap, then that gives us greater strength to chop that out. So on the southern part, because it was the fisheries, because it was SLVIM, because it was shipping, it gave us much more, there was more like a stronger emphasis to basically remove that area from development, hence why it was taken forward. It wasn't that one was in isolation. To the top, we had some navigation issues at the northwest corner for the Bahama Buoy. So we could have made that, but the shipping stakeholders said that they didn't really want it. So the reason that all of the array area is cut at angles is to maximise the amount of return in to minimise the lateral spread of turbines at critical viewpoints. So from Mackled Head looking down, hence why it's orientated with the viewpoint line that way, the orientation. So there was a lot of consideration, and we can provide some additional information from an SLVIA viewpoint perspective of why the lines are cut the way they are and why the proportions are the way they are.
I understand what you're saying. I think I've asked the question a number of different ways, so I think it's for the panel to now have a think about what you've said, read the transcript, and then go through if we need any further information. Thank you.
So, Dr. Carolyn, I think, and Ms. Sterling, I think you can see that we're not satisfied with your response. And there's several things that we want to understand. And my original question I don't think has been answered, which is the commercial considerations and how they were weighed against in all of these matters. So we've kind of talked about the wireframes of, what the landscape impact would have been for if you'd built out the entire AFL area, and how you feel that the landscape impact of this reduced area is in fact better. So that's one. Two, what were the shipping considerations that you took into account? What were the safety considerations? So let's say landscape was not a consideration at all. How much of the AFL would you have been able to build out in terms of shipping and fishing considerations, or to mitigate shipping and fishing considerations, which will potentially give us an idea of, what is the consideration of landscape, or what were the amendments, or how the design evolution took into account the adverse effects on landscape. And then the third point is how has commerciality played into all of this? So, and this sort of, and the thing is that this conversation has very much started somewhere in the middle of the entire picture that I would like built for me. The initial part of the story is very much how DOI arrived at the AFL with the applicant, what environmental considerations, and what I'm trying to almost understand. And I think this might be confusing, which is why I wanted to take away with the panel, but is what was that appraisal of sustainability when you chose the site for the agreement for lease? So I think there are several layers of questions, and while we have a lot more clarity with what you're saying, we're not satisfied with what you've given us so far. So I think there's going to be a range of hearing actions for you to clarify some of those points. But if you want to come back on some of the points that I've raised, that'll be helpful.
Yeah, Dr. Keoghan, on behalf of the applicant, we weren't prepared for the scrutiny on this matter today, so we're sort of taking a lot of this on the hoof. I can speak just in relation to shipping and navigation. So with the red line boundary, we had 3.5 nautical miles between the red line boundary and Isle of Man steam packet route. We thought that was sufficient sea room. You'll have heard from the representations from the Isle of Man steam packet that they didn't feel that was sufficient sea room. So that was one of the key drivers. We also had access to some of the Queen's Scallop grounds, high-value Queen's Scallop grounds, which occur along the southern boundary. So we took that into consideration also. One of the key things was the lateral spread, as I said, of the SLVIA. Just to touch on the commercial part, I mean, offshore wind farms are competing in a very competitive environment now for contract for difference. And the scale of the project we must seek to maximise that project and make it comparable with other projects in the East Irish Sea, so Morgan, Mona, and then projects in around 1.5 gigawatts, so projects that we are going to be competing with in an economic market in the future. So the scale of our project, we're looking to get in around that plus gigawatt scale. The project had 100 turbines in the beginning, and what we're seeking to do is to get a project in and around that greater than the gigawatt scale. So that's the commercial aspect that we're seeking to balance.
Thank you, Dr. Carolyn.
Amy Sterling, on behalf of the applicant, if I may just to draw all together. Ultimately, we don't in the UK and Isle of Man, these projects are undertaken by private commercial entities. It would be remiss not to obviously appreciate there is a commercial element to that. We're not.
Ms. Sterling, I don't think that's in doubt.
Okay, I'll just finish the point that I was making. And so, as a commercial,
Ms. Sterling, before you conclude, can I just bring in Mr. Strafford, who's had his hand up for an awfully long time, and then I will turn to you before we close this item. Mr. Strafford.
Thank you very much for bringing me in, Ian Strafford, resident of Laxey. Two observations, if I may. Madam Chair, I think when you started your questioning, you actually started from a viewpoint of the 2015 agreement for lease, where it was 100 turbines, and based on what we saw on interviews in 2015, approximately 180 metre tall. I think you were asking the question about the evolution and how it had been assessed to go from that size of turbine to the 350 metre turbine. Listening, it seems like the conversation has just moved to focus around 87 or 100 350 metre turbines. I don't think I've heard anything with respect to impact on visual impacts as a result of going from 180, 190 metre turbines to 350, although I appreciate there's no doubt a commercial impact to that.
You've just stolen my thunder, Mr. Strafford.
Okay.
I have a few questions on that matter, but I'll hand back to Ms. Fernandez before she
if I just
concludes.
make the second point I'd just like to make. The key aspect for me in this is in whatever modifications have been made is, has it fundamentally affected the outcome of the assessment? So on all the visual receptors from the point of air down to pretty much, I think it's Langness, it still remains major. It was major when it was 100 turbines, it's major when it's 87 turbines, it was major when it was 389, it was major when they're 350 metres tall. So arguably, the concessions that have been made have not affected the outcome, and therefore, in essence, there haven't been any concessions made for the visual impact, and that would be the point I would ask you to consider. Thank you.
Thank you, Mr. Strafford. So, and I will come back to you. Ms. Sahai, did you want to, because I'm conscious also that we're going to go to coffee as soon as we finish this item. I just want Ms. Sahai to gather her thoughts, and then applicant, I will ask you to come back. So I think we'll probably come back to this just after coffee, but I would like your response now as to what you've heard from this conversation. And obviously, it's not a surprise that we're asking these questions and we're puzzling over them because of the significance of the question in relation to the AFL and the mitigation that was part of that early design development. So let me hear what you're saying, and then we'll go to coffee.
Amy Sterling, on behalf of the applicant, thank you for the opportunity. to respond. I think a couple of key points that I want to make. I hear you, that you're not satisfied as to how we've applied the mitigation hierarchy for SLVIA and what the balance between the trade-off essentially between landscape and visual impact and the commercial incentive to maximise the seabed efficiency. We will take that away and we will provide you a response in writing. As Dr. Carolan mentioned, I think it is a more specific response based on specific viewpoints rather than a one-size-fits-all, hence the lines are the way that they are. You know, the trade-off at one viewpoint, okay, well, if we moved the turbines X, it would still be a major adverse effect. Therefore, the loss of generating capacity is disproportionate to the EIA benefit, essentially, that would accrue. And I think it's that level of analysis which we are able to provide you in writing. I think a couple of things that I would like to be clear on, though, is that just because, for example, something has a shipping and navigation benefit or a fish ecology benefit doesn't mean it doesn't also have a seascape, landscape and visual impact benefit. So if we were just to say, well, this is mitigation for shipping, that doesn't also mean it's not mitigation for seascape. And so I would caution against looking at only things that are seascape alone, because as I mentioned, as part of good project planning, those are considered holistically. The final point I would like to make is just in relation to the turbine specifications that were mentioned by Mr. Stafford. It wouldn't be possible to build an offshore wind farm at 180 metre tip height. That kit isn't on the market. You know, the technology has evolved significantly over the last decade. Therefore, our application reflects the current market for wind turbines. Thank you.
Yes, thank you. And I do want to bring in Miss Newton, then I will come back to you. Miss Newton.
Thank you. I just wanted, before you go for your break, and given the discussions you were going to have at the break, going back to planning policy, you've got strategic plan, it's dated 2016. In fact, the 2016 was a revision of the 2007 plan, but only in terms of population and housing. The environment policies in 2016 are in fact those from 2007, and therefore they predate anything that was discussed or put forward in terms of wind turbines and energy policy in 2014. I think you've got to take into account that there is an emerging landscape plan coming out in the revised strategic plan, and that this may well have an impact on how we look at wind turbines in the future. The other aspect of this is, and it will come up in the next section, is that where there is an area plan that postdates the strategic plan, that takes precedence over the strategic plan if there is a conflict between the two plans. The area plans are meant to tie in with the strategic plan, but they don't always. So the policy, in particular landscape policy, in the plans that have postdated the strategic plan, they take priority. So that particularly applies for the area plan for the east.
Thank you, Ms. Newton. Let me pick that one up just after the break, and we'll just want to clarify that that's understanding of DEFRA and DOI, Cabinet Office on that one. Applicant, did you want to say anything before we go to coffee?
Amy Sterling on behalf of the applicant. No, thank you to Ms. Newton for those points. I think the action remains that we will discuss with DEFRA and the DOI the environmental policy framework for the grant of the agreement for lease. Also to confirm, we have assessed the area plans within the SLVIA, and Mr. Martin can speak to those after the break. Thank you.
Okay, thank you. Let's come back at 12:05. Thank you.
2. One, two. Turn it down. Two. Test.
Okay. Okay, if I could bring us back to order. It's now 12:05, and we're going to finish off the item from just before coffee, and I believe my colleague, Ms. Sahai, has some follow-up questions now that we've had time just to pause and reflect on some of the conversation and to tidy up an action point. So I will hand across to Ms. Sahai.
Thank you, Ms. Fernandez. So if I could just ask Mr. Garden perhaps to come back onto screen, because this action is something that we discussed just before the break. It was talking about the choice of AFL and the location of the seabed to lease. And I suppose the question is, if any, or what was, if any, the environmental considerations when you were choosing that location? And that's, in quite simple, basic terms, that is the question. What were the environmental considerations? Given this is a national infrastructure, given that you were aware that this was going to be a national infrastructure project with adverse effects, what, if any, were the considerations given to environmental effects? And just to follow up that point, I think what we would like to understand is if there was the equivalent of the considerations that you would typically need to, under the SEA directive, need to take into account, whether any of those considerations were taken into account. Is that clear, Mr. Garden? I know you're taking that away as an action, but I just want to clarify if you're clear what that action is.
Robert Garden on behalf of the Department of Infrastructure. That is clear as an action, and we can take that away.
I'm just wondering if this is perhaps because of the lack of information before the examining body in terms of, how the agreement of lease was. Actually, let's just leave that as an action. We will follow that up with further written questions, just to give us a little bit more time to process it. Okay, so that's done. And then there's just a few other things that I think we left the conversation slightly halfway. Just before the break, Ms. Sterling, you made the point that the three limiting factors, fishing, shipping, and SLVIA, were considered in the round when this scheme was being developed, when the red line boundary or the order limits were being determined. And that point is well made. We accept that. You also made a point that if something was benefiting the safety requirements of shipping, it does not mean it was not also benefiting the landscape. That point is also well made. But we would still like to understand that if fishing and landscape considerations were not in the mix, and it was only shipping safety considerations, what would the order limits look like? Not to discount that the changes to the order limits made because of shipping safety considerations would affect or improve landscape effects. We would still like to understand this is very specifically the safety considerations that were taken into account when making changes to the order limit.
Amy Sterling, on behalf of the applicant, yes, that's understood. I'll just say it back to you just to make sure I'm clear. So you want us essentially to depict only from the agreement for lease area, only the areas which have been removed for shipping, not SLVIA.
That's absolutely correct. Okay. And I think what would really help us is if you showed us the blue boundary, the red boundary, and a dotted boundary showing us the consideration, the specific new boundary that I'm asking for, the safety considerations for shipping, as an overlay of all three things. Yeah?
Amy Sterling on behalf of the applicant, that's clear. Thank you.
Okay. All right. Okay. There's a further follow-up point from the conversation we were having where we were starting to take into account commercial considerations. And you made a point, which is that the loss of generating capacity, you felt that the trade-off with the improvement or the environmental impact assessment was not, I think you said the trade-off was not worthwhile.
Amy Sterling, on behalf of the applicant, disproportionate was the word that I used. And I also wasn't saying that specifically in relation to any viewpoint. I was suggesting that that's the work that we need to do to present to you, to explain the thought process, where we've gone through and considered were there any further SLVIA mitigations that could be put forward in terms of the boundary or the location of the development, and what impact that would have on the generation capacity of the development, and then what impact it would have for EIA purposes. And there is inevitably some level of proportionality in that.
So it's essentially an action that you set for yourself, which is very, very helpful. So if you could just have a note of that. But I just want to follow up point on that. You did talk about generally the Irish Sea as being potentially, other offshore wind farms and being your competition in terms of, what you're generating, and you need to compete with these other offshore wind farms, which are in the region of 1.5 gigawatts. Have I understood that correctly? Because I have a follow-up question on that.
Amy Sterling, on behalf of the applicant, I think what Dr. Carolan was referring to was generally the practicalities of developers who participate in the contract for difference regime in the UK, and the fact that there is ultimately a level of threshold which makes a project competitive or not competitive, and it's the applicant's commercial interest to ensure that it is competitive and therefore delivers the project.
So if I am to understand it, and I don't want to labour on this too much because we will come to this in SI 87, so it's not really an SLVIA matter, but if I've understood it correctly, when you're talking about the competition, it's not about selling to market, it's not about getting a grid connection, it's about the CFD. Understood. Okay, so we'll pick this up at SI 87. And then the final point, which which Mr. Stratford picked up, and I want to, just start that discussion, is this whole thing about the evolution of the scheme. Now, we were talking about this over the break, and I think we just want clarity that you have the AFL boundary, you had an old scheme which had a certain number of turbines with a certain height, with a certain generating capacity, which was about 700 to 800 megawatts. And then you reduce that down, or rather, with the newer turbines, you increase the generating capacity, and with the environmental assessment, reduced, pulled back from the AFL boundary to get the order limit. So, just clarify clarify for the examining body what were the main steps. And particularly with reference to the height of the turbines, the number of turbines, and the pullback from the AFL boundary to the red line boundary or the order limits that you have right now. I think in my head there are 3 steps, but I really want to understand from you and just clarify for people in the room.
Amy Sterling, on behalf of the applicant. Yes, I think it's important to clarify. The first point is that the applicant was awarded an agreement for lease, and there were certain assumptions at that time based on the market as to the number of turbines, the height of the turbines, and therefore the generating capacity. Okay. It's not that obviously the agreement for lease is a commercially sensitive document, but it's not like the applicant was only awarded an agreement for lease for a certain number of turbines at a certain height. That's not the case. It was a spatial option. It is a spatial option agreement that the applicant can seek to rely upon for its MIC application. So the figures that are being discussed, the heights and the number of turbines, were based on the current market at that time. That market then evolved between the agreement for lease being awarded and the applicant carrying out its scoping exercise, which was a precursor to the MIC application. At that point, at the scoping exercise, the applicant revisited the spatial extent of its agreement for lease, the option agreement, and the current prevailing market conditions at that time carried out a scoping exercise on the agreement for lease boundary with the 100 turbines, sought feedback through the scoping exercise, made some design refinements, carried out a preliminary environmental assessment, carried out a statutory consultation, carried out some more refinement, which ultimately results in the IMIC application. But it's not the case the applicant had an EFL for a certain number of turbines at a certain height, and that has changed. It's the assumptions have changed.
So what you're saying is that the assumptions in the agreement for lease were only notional. That was never a scheme.
Amy Sterling on behalf of the applicant. I do need to be careful. The agreement for lease is a private commercial document. I would need to see what I can say, but it would be unusual, I guess I could say, for an agreement for lease to specify a number of turbines. That's not the role of the agreement for lease.
Is the agreement for lease a commercial document that cannot be shared?
And can I just follow that up? Because even if it is, there are dimensions of it that are prospectively highly germane to the examining body's understanding of what the primary drivers for the scheme in front of it actually are, and also how that has evolved. And I guess my starting observation then would be that it would assist us very substantially, and I think it would help to address some of the extensive concerns that have arisen from public participants in this process and allow them to form their own view about where they sit in relation to concerns that they have expressed. If the dimensions of the agreement that essentially describe the area extent and the broad development assumptions or parameters, to the extent that those are described, were be able to be put in with other commercial provisions redacted. I don't think anybody is asking you to do what no one has previously asked, namely to show the precise content of the commercial negotiation. But to the extent that that agreement determines that an extent of sea is in consideration, and that there were any parameters in terms of likely spatial form or distribution of use or development in that area of sea, and that can be brought in with final numbers and final commitments on either side that are genuinely commercially confidential, redacted, then that would be very, very helpful indeed.
Amy Sterling on behalf of the applicant. In principle, sir, it's not something we're averse to, but it's not something I can unilaterally commit to do because there are two parties to that agreement. It's the applicant and the Department of Infrastructure. I note Mr. Garden has got his hand up. I would suggest that it's between the applicant and the Department of Infrastructure to discuss this matter and consider between them if they're able to submit the agreement for lease in a redacted form, or at least the principles arising from that agreement for lease. I note Mr. Garden's got his hand up.
Yes, mindful that there's more than one person and one party involved in this. Mr. Garden, and equally, I'm not wanting to put either party on the spot, but sometimes a consideration in the calm light of the next day may find a way forward that would be helpful to the XB as opposed to a knee-jerk reaction that might be a no. So, Mr. Garden, what are you thinking?
Yeah, Robert Garden on behalf of the Department of Infrastructure. I don't think I have an answer for you today because the relevant commercial people aren't here, but in principle, I was going to make the statement that Ms. Sterling has just made in terms of working together and looking to see what we can do to submit to the examining body to help with this line of questioning. So we will take that away as an action point, but I think in principle see no issue with disclosing certain elements.
And Mr. Garden, Ms. Sterling, I think you can see the logic behind the few things that we've asked for. It's just completing a picture for us and helping in our mind build that narrative that how did you arrive at that location is something that you're already taken away. What were the considerations? What were those agreements between the two parties on that basis, which hopefully you can show to us in some redacted format. And then going from there is this narrative, which, Ms. Sterling, you've very helpfully shaped for yourself, which is what is that thought process in terms of the commerciality and the trade-off a proportionate trade-off between commerciality and the environmental effects. And in doing that, I'll just pause on that point and dwell on it just a little bit. In doing that, I think what would really help us as well is just understand that if commercial considerations were not in the picture and you were to reduce the scheme down to quite a lot, at what point does the SLVIA become negligible or, significantly less? And there, I can see Dr. Carolyn nodding his head. There might not be a point at which it does, but that might also be a very helpful picture for us to paint, for you to paint for us, And then I don't want to start rehearsing all of the actions, but you can see where we're heading to with this. So I think that kind of completes the points that I have to make.
Applicant, is that clear? Do you need anything further?
Amy Sterling on behalf of the applicant. Yes, I think we're entirely clear. Thank you.
Okay, and another bit of a sweep up, which I'd like to do from agenda item 3. Just before the coffee break, Ms Newton raised a couple of points in relation to the area plan and the status and the history. And I did ask you, Cabinet Office, if you just confirm your understanding, just so that we can, correlate that understanding.
Absolutely. Diane Brown for Planning Policy for Cabinet Office. The strategic plan, the Isle of Man strategic plan, was originally approved by Tynwald in 2007. There was a very focused update in over 2015, and the strategic plan 2016 was approved by Tynwald. The policies that were altered, I can agree with Ms Newton that they related to Housing Policy 1 and Housing Policy 3. Strategic Policy 11 was the same as Housing Policy 1, so in effect it was just those two policies. To help understand the changes, I think looking back at the Strategic Plan 2016, the preface from 2007 was kept and there was an update done. So at the very start of the document, it tries to explain why there was just a focused update. There was a reference there to general conformity. There is a provision in the Act that all area plans must be in general conformity with the strategic plan. Generally, when we come to area plan examinations, inquiries, occasionally, and this was the case with the area plan for the East, there was a little bit of discussion about whether the area plan for the East was in general conformity with the strategic plan. So it is taken into account for each plan, generally speaking. In terms of the strategic plan review, the preliminary publicity documents were published in August 2025, and I think in my letter dated the 5th of May gave a link to all of those, to that public consultation that took place. So we are looking to update the strategic plan, and that's work ongoing as we speak. I think that covers everything, but if there's anything else the panel would like to question me on, that's fine.
And I think the other point that Ms Newton raised was about the hierarchy, and does the area plan trump, using colloquial English, the strategic plan if it's more recent than 2016?
I think the Act does say what I can take you to the exact point if necessary, but yes, where the area plan is more recent, then the provisions of that plan I wouldn't say the word trump the strategic plan as you used. I could say that, but yes, certainly. But at the time that plan is looked at, it is looked at in terms of, is that area plan in general conformity with the strategic plan? That's generally done ahead of adoption and approval.
And on the basis that it is deemed to have been in general conformity, then when in matters of specific detail it creates greater precision or some measure of possible difference with the SP, if it's newer and in general conformity, it is then the operational policy that is preferred.
That's right. It's a very good summary. Thank you.
May I just bring in Miss Newton, who had her hand up just on this point? If the roving microphone could find her, that would be super.
Thank you, Patricia Newton. Just to clarify, in the strategic plan itself, paragraphs 1.4.3 and 1.4.4, the latter says, in the case of any inconsistency between the provisions of the strategic plan and the provisions of an area plan, whichever came into force later will prevail. So that it's confirming what Ms. Brown has said about the Act, but it is actually written in the strategic plan itself. Thank you.
Thank you, that's helpful.
Amy
The
Sterling,
applicant.
on behalf of the applicant, it was just to confirm, I mean, I think we're seemingly all in agreement, it's section 2.4 of the Town and Country Planning Act 1999, which sets out in law that hierarchy of the latest planning policy prevails.
So what we're saying is that whole plan takes precedent, not a policy in the plan. That's what we were trying to establish, I think.
I think it's the proposal. So what the specific section says is the proposals in an area plan shall be in general conformity with the strategic plan. So the strategic plan, I would say, has hierarchy. The area plans are to conform with the strategic plan.
Right.
But in the case of any inconsistency between the provisions of the plan, the strategic plan and the area plan, whichever came into force later shall prevail. So I guess it's the latest formulation of government policy on any particular topic shall prevail between the two.
Thank you, that's very clear.
Great, I'm glad we agree on something. Okay, so let's take us now to item 4A. This is about the onshore seascapes effects in the Isle of Man. I just want to talk briefly about visualizations and then to look at document D1024, which is a technical note on visibility frequency, which was submitted at D1. But just before I do, and to allow people to perhaps look that document up, just to confirm that the examining board has visited all the viewpoints identified in the Isle of Man and also in England. We will also look at the Scottish ones, but at this point we haven't done that. And we are very mindful that in looking at the viewpoints and the wireframes that have been provided, that these are helpful, but of course what they don't show is the 3D, the smell, the noise, the panorama. So they're a helpful tool, but by no means the whole story, hence why for us we've undertaken a lot of unaccompanied site inspections and we'll continue to do so until the close of examination. So let me then turn to document D1024, visibility frequency of the offshore array. And I'm conscious that some people will not have seen this. Applicant, would you mind providing a concise summary of the findings from that submission, please?
Simon Martin for the applicant. So we provided this document building on data supplied by the Isle of Man Met Office, which is based at Ronaldsway Airport, and it just allowed us to, I suppose, contextualise some of the seascape and visual effects of the project, looking at visibility frequency that is recorded at the Met Office. So they take visibility measurements over time. We took a 10-year sort of sample of visibility data over that time, and we were able to, I suppose, map and present in tabular form in the document you mentioned in D1024 the total visibility frequency at different distances. So that just allowed us to make some, I suppose, conclusions on the likely visibility at different ranges and how that visibility might be experienced, how frequently it might be experienced at different distance ranges. We can go into some of those findings, if that's helpful. I suppose just maybe before I do that, just to contextualise that ultimately the findings of the Seascape Landscape Vision Impact Assessment have been based on the worst case scenario. So our impact assessments in the written assessment are based on sort of an assumption of excellent visibility conditions. So this document is really not necessarily to try and minimise some of those effects, but just to set them in context in terms of how frequently they might be experienced at different ranges. I think some of the headlines that we found in that document are set out in 1.3, section 1.3 of D1024. The closest sections of the Isle of Man are roughly 11 to 20 kilometres from the offshore array, so that's sort of the eastern seaboard between sort of Point of Ayre in the north and Langness in the south. From that range of distances, so beyond 10 kilometres, we found approximately 83% of the time one would have visibility beyond 10 kilometres. And then with increasing distance, that reduces. So some of the more distant parts of the island, so between Listleness and Langness in the south, for example, beyond 20 kilometres, there is likely to be visibility for approximately 59% of the time across the 10-year sample period that we had. So that would be effectively during excellent and very good visibility only. When you have good or moderate or poor visibility, for example, which amount to 41% of the time, the offshore array would be unlikely to be visible in those kind of conditions. And then obviously increasing with distance, that tends to reduce, the visibility frequency tends to reduce with distance, so around 29% of the time for distances beyond 30 kilometres. Those are the relevant range of distances for the Isle of Man, and then beyond that, the visibility frequency reduces for some of the transboundary receptors that you mentioned in England and Scotland, which are out to sort of 40, 50, 60 kilometres in parts of Scotland, where you really are reducing down to very small amounts of time where you have the most excellent visibility conditions.
Thank you. And I will come to Hans when I finish sort of my line of questioning. Thank you. So it was based on Met data from Ronaldsway. Have you had any data from Blackpool, Walney, Stranraer? Is there a need to correlate that data?
But potentially, yes. We did focus in this work on the Isle of Man visibility frequency data. There is a weather station at Walney as well on Walney Island, which records visibility. They don't all record it. That's something we could potentially do to try and corroborate the results, to look at those transboundary receptors. But I think I would expect it to demonstrate a similar finding, a similar range in terms of decrease of visibility over distance. There might be some slight differences in the numbers, but broadly speaking.
Okay, thank you. I think that would be helpful just to correlate, and I'm sure the findings won't be changed much, but it would be useful to correlate. And also in terms of seasonality, what variation was there in terms of seasonality in relation to the data?
So Simon Martin for the applicant. So the data is, I believe it's collected it's over a 10-year period, over a 10-year sample period. It's recorded. I think it's recorded daily, so it is recorded across the year, and then aggregated in the findings that we presented.
Would it be possible to look at those findings and provide us a seasonal representation of that visibility?
Yes, I think that is possible. Yeah, I think the raw data that's been provided does break it down into monthly recordings, so we should be able to tie it back to seasonality, so we can see the difference in the summer and the winter.
I mean, I think if we could do it by month, if you're saying the data is provided monthly, then let's have that monthly. Okay. And so from my looking at those findings, and indeed your summary correlates with what I had understood, visibility between 10 and 20 kilometres, the visibility is good 80% of the time. Is that how you would describe the findings between 10 and 20 kilometres? Up to 20 kilometres away from the coast, how often is the visibility good or excellent?
Yeah, so the total of, so I'm just checking the report here. So you have to total up all the visibility recordings, and what we did was look at, so all the visibility recordings beyond 10 kilometres are relevant for the Isle of Man because of the closest distance of the coastline at 11 kilometres. So that would be at 83% of the time.
And so the visual concentration between 11 and 20 kilometres is greatest, that's when it's most visible. I mean, that sounds like a truism, doesn't it? It would be most visible from the nearer to the coast you go.
Yes.
And that the effect decreases quite significantly beyond 20 kilometres. Would you agree with that?
Simon Martin for the applicant. Yes, it drops notably beyond 20 kilometres, where you're, I think I said it was about 40% of the time that you would be unlikely to have visibility beyond 20 kilometres.
Okay, so again, to test this proposal, what would happen if the array area was moved beyond 20 kilometres from the coastline?
Amy Sterling, on behalf of the applicant, it wouldn't be in the Isle of Man territorial waters anymore. That's my understanding. I think I would just need to run the figures, but I think... Amy Sterling, on behalf of the applicant, if you started at 22 kilometres, you would go outside of the boundary. I think it's about 22 kilometres, I'm being advised, to the boundary.
Yes. I mean, I don't think the question was framed in those terms. It was essentially looking at accepting the outer bound of the Isle of Man's territorial waters as a given. There may be a slender patch of water left, but to try and deal with the hypothetical question of what the effect would be if development was occurring in essentially the space remaining between 20 kilometres and the outer bounds, because there is a 2 kilometre stretch. You could equivalently ask a similar sort of hypothetical question, reducing back to 19 to 18 to 17. I think Ms. Fernandez is just trying to work out where, if anywhere, there is a reasonable boundary of shift of caused effect as a consequence of setting back wind turbine generator structures in the red line boundary area.
Amy Sterling, on behalf of the applicant, I don't have the answer in front of me that if we were to take the red line boundary already abuts the seaward boundary of the Isle of Man territorial waters.
We're conscious of that.
Yeah, so if we were to take the landward boundary out to beyond 20 kilometres at each point from the coast. I'm not sure if what that would leave us with, because it's not a straight line. So
it isn't a straight line.
Assuming that was 2 kilometres, we'd have to run the numbers as to how many wind turbines you could fit within that 2 kilometre spread. Obviously, there is a minimum spacing distance between the turbines as well, which of about 820 metres, I believe, from centre point to centre point. So I don't imagine it's many. At
this juncture, it is a thought experiment, but what we're trying, I think, to achieve here is a sense of, yes, as I hope I've articulated, the distinction between the distance of setback necessary to begin to deliver a material reduction in adverse effect due to a material reduction in the likelihood of visibility distributed across the year.
Amy Sterling, on behalf of the applicant, understood. So I think it is important to note that even at 20 kilometres, the assessment would show that it would still be visible 59% of the time. So I'm not sure that does take you into a no significant effects category, but I could, Mr. Martin can opine further, or I think that's something we'll probably have to take away.
So, I mean, of course, all of these questions are just testing the parameters in which you have assessed the project, and is there mitigation that could work by looking at this in a different way. So I would like you to take that away as an action, just to understand what would the implications be if that were to happen and you were to design it or not. Okay, thank you. And then just on the visibility question, I had a hand up from somebody, and please could you remind me of your name and then I'd like to hear what your question was.
Yes, my name's Carlton Freegard. I'm representing myself. I would caution the committee in looking at the visibility data from Ronaldsway. The whole of the East Coast has various microclimates, and it can be very sunny and have a great visibility that will literally drop after about 6 or 7 miles to almost nothing. So please bear that in mind when you're looking at those things.
Yeah, thank you. Applicant, did you want to come back?
Amy Sterling, on behalf of the applicant, no, nothing further.
All right, then let's now turn to item 4B, and this takes us into nighttime effects. And Ms. Newton has provided a number of photographs to show the aurora borealis, and these seem to show that it is visible from the Laxey east coast of the Isle of Man, yet you state that it only occurs to the north. So this photographic evidence would suggest that there might be an effect. Ms. Newton, did you want to add anything further on that?
Thank you. I don't really want to add much to it other than clearly the aurora is more frequently visible from the north and northwest, but to say that it is not visible from the east is totally erroneous. We have had some wonderful displays over the east, and you will find any time that there is predictions that there will be an aurora, you will find cars parked all over the island, all over the mountain road, all over the coast roads, Ballarat East, everywhere, where people are trying to see the aurora right from the Point of Ayre down to the south. I myself was chased around trying to find it, and at times, and one night I couldn't find it. I was parking up at my house in Laxey. I looked up through the clear window above my car, and there it was all over the sky. I then went up to Axonfell. Unfortunately, only found one other car there, and we enjoyed the whole display ourselves. So it is totally wrong to say it is not visible in the east. And we've had a lot of occurrences. In just April this year, I submitted for deadline 2 or deadline 3 and the most recent one, a photograph that I tried to take. My either I or my camera are not up to getting very good visualizations. But that was taken in May, about 2 o'clock in the morning after I'd finished trying to work on this. And it showed the red lights of the existing Walney farm, the remains of what I thought was the aurora, which someone else had seen and photographed up at Andros, which is not on the coast but is on the northeast side. And also something else going on in the background. I don't know if it was a barrow or to do with the Walney farms with very bright lights. So it is definitely very, it's a case of catching it and seeing it. I don't know how often, I can't tell you what frequency there is, but we do have it, and the red lights of 1,000-foot mast flashing in the space between the coast and the just the dark skies that you get will actually totally spoil the aurora. It will totally spoil the effects of dark skies on the island, of which we've got 26 sites. I think that's going on. Maybe that's going on to your next point. But while I remember, can I just point out for both aurora or dark skies, the applicant has said that they don't want you to go out at night to look at recognised dark sky sites, which have been suggested, I think, at Axonfell for one, because of health and safety risks. It's absolutely ridiculous to think that we would have internationally recognised, or at least nationally recognised dark sky sites in accordance with the convention on, at sites which were health and safety risks to visit at dark skies. So I would request that you do go out, and if there's a suitable night, and that the night you'll be far better if you could do that during your visit this week than in a visit in July, because obviously you'll have far less opportunity to actually get a dark sky in July than at the moment. Even now, in the early hours in the morning, you can almost see what looks like a sunrise effect in the very far east, so you've got to catch it at the moment. And the skies in the past week have been brilliant.
Thank you. Thank you. I will come back to you, and then we've also had representations from various people on dark skies. So I'm just going to gather a few of these together. There was quite a lot of representation about the concern about flashing lights, red lights affecting the dark skies status, and that was PCR 267, but there are others. And Joanne Parkins, D1180, expressed concern that dark skies status, and particularly around Muckled area, would alter the character of the protected environment and create visual dominance at night. And is your point from related from that, Mr. Henthorne? Yes. Yeah, please do speak. And if you would introduce yourself.
Yeah, it's Richard Henthorne, Garth Commissioners. I just wanted to point the committee's focus towards our own opportunity to view the dark sky environment with the turbines in place that we were given at the consultation at the Laxey Pavilion in the initial consultations. Only a few of us were really given the opportunity to view the dark sky and the nighttime navigation lights through a set of 3D or visual reality goggles. And to be honest, they made you a little bit dizzy when you put them on, so you had to sit down, you didn't really want to view them for too long, which might have been on purpose. There have been no further opportunities to visualize the nighttime scenario since that point. We had some elongated pictures from Orsted that were given to us that we did actually put out in our a little get together and drop-in session on Saturday at Laxey. But really, it was literally hundreds of blinking little red lights off the east coast and visible, you know, they'll be visible to every household from the Point of Ayr to Langness and the mountain and beyond. And each turbine has to have 3 lights on, I believe, for navigational purposes. When I expressed my horror at the sight of these lights flashing all night long, the operator said to me that instead of all flashing at the same time, they could be altered to flash at different times, which would actually make it even worse than it was now. I wrote to John Galloway after this last year and asked him if the images to view through the 3D goggles would be available again, because very few people at that meeting got the chance to look through these goggles, and they're nothing like the pictures that were provided, the static pictures that are provided by Ørsted. It really is quite an eye-opener to see through these 3D goggles, but unfortunately John Galloway said that no, that those images would not be available again. And I think that possibly might be because you know, it is quite an unpleasant sight. Anyway, for those who want to imagine it, it's just a sea of hundreds of blinking red lights all night long, every night, forever. Now, I've since recently been told that they can operate these lights for navigational purposes when planes are coming to be close by, and they can switch on and switch off as necessary. Yep, but this is a very expensive fitment for this operation. So I just want to know if you've seen through the 3D goggles, and if not, you should have a go.
Thank you. A couple of things I just want to pick up there. You referred to the drop-in centre and some additional visualisations that were shared by the applicant. Have I understood that correctly? And yes. Are they existing viewpoints and photomontages, or is this new or different material?
They're Ørsted's own existing photomontages.
Let me just check whether they're different to the ones that we've already received, please.
Dr. Kjorn, on behalf of the applicant, they're not part of our submission. They were materials that we provided for the community consultation events, and you need 3D headset to view them. So they were created to give an impression of what it would be like from key viewpoints, say at Laxey. So you could stand at Laxey, put the headset on the beach, and you could look then and see the wind farm, various different stages of the day and various different lighting conditions. So to give the viewer an idea of what it was like, a 3D real world representation as opposed to a landscape visual impact like photo montage. So it was an experience created. It wasn't limited in any opportunity for anybody to use it. They were there freely available, all our consultation events promoted by ourselves. So they were there and everybody made use of them and made comment.
Amy Sterling on behalf of the applicant. If I may, I think we're just talking at slightly cross purposes. The virtual reality headsets were a consultation tool. The visualisations for the meeting that were held are based on the visualisations which are submitted into examination. They were just provided by the applicant, I believe, on sort of information boards for use at that event, which the applicant did not attend.
Okay, thank you for confirming that. Those goggles sound quite interesting. I wonder if we might, and I don't quite know, we need to probably think about this, whether that's something we could look at on an ASI with the goggles. But should we perhaps all just take that away and think about whether, one, we can ask that, and two, whether you can do that. But it's something that sounds potentially useful. And
just on that point, if we were to request something like that, and notwithstanding that whether or not you're able to actually provide that, what would be the benefit to the examining body if we were to, be able to see, or have the same experience that has just been described to us?
Dr. Kjorn, on behalf of the applicant, I don't know what benefit it would be to you. It would give you a similar experience to that experience that we offered to other participants at the community consultation event. It's not a real world representation. It's not an assessment tool, so it's heavily caveated in that approach. So, and we promoted it as such. It was to give people an experience of what it would be like from viewpoints that were particularly sensitive. So like at Lexi Beach, so that they could get there, instead of looking at a viewpoint or a montage, they could be immersed in their environment and somewhere that they were familiar with to get a sense of the scale of the development, really. So we would happy provide those again. That's not a problem. It is available on our consultation online. So, but it's not available in 3D. You can watch it just as a video, but we can look into having, I think we still have the headsets, so it's something we could arrange for you.
And I will come back to you. Was it based on the worst case as shown on the visualizations or something different?
It was based on the maximum design scenario. We did struggle slightly with, we had a local contractor who created the 3D visualization, so we did have a little bit of a problem with the atmospheric haze and with getting the correct candela values for the lighting. That proved to be a bit of a problem, but getting the layout and getting the photo montages and everything was taken from a drone, so it was realistic in that respect in terms of what a layout would look, so you could see the full extent across the horizon while standing on Lexi Beach, so it was quite informative and immersive. But the nighttime part with the lighting, we couldn't recreate the correct lighting at the distance from the wind farm to the correct brightness that it would be, and that was a bit of a flaw. So it does exaggerate the nighttime lighting perspective that the gentleman refers to, but we can make that available. This was all caveated, so it was just there as an immersive experience, not a representation of what we wanted to build.
Mr. Henthorne, you wanted to just come back, and I think the microphone always seems to be far away when everybody wants to speak. It's just for the audio, so it just helps if it's on the microphone.
Yeah, just to answer your question from my point of view as to how it would help the panel view the image, it brings it alive, it brings it into reality, rather than the flat picture on a piece of paper. It brings the whole thing into life, and it is quite, and the gentleman quite rightly said that there may be some atmospheric differences between reality and what was shown on the image, but it certainly almost makes you step back when you put them on, because it is quite an eye-opener.
Yeah, thank you. So I think that would be helpful to have at an accompanied site inspection. However, we would make it clear, and we do need to think about it, so let's take this as a caveat, subject to the panel having time to think about it a bit further. It wouldn't be evidence, but it might be helpful as a tool on a site visit. So I think that's the way we probably think about it. So not evidence per se into the examination, but a tool that might help us to understand nighttime visualization. So let's think about how we might affect that. And then, I'm just having a few IT issues.
Amy Sterling on behalf of the applicant. If you don't mind, Madam, just a couple of observations. First is that the virtual reality experience, as I understand it, was based on a previous design iteration of the 100 turbines. So question how useful it may be for context setting. I would also agree with your position that it shouldn't be used for assessment purposes, because obviously the assessment has been based on published and established guidance, wirelines, viewpoints that have been undertaken in accordance with industry practice, not consultation tools, essentially.
Yes, that's understood. And I'm going to come back to you with dark skies, but there was also another point which I just wanted to acknowledge from Miss Newton. We've had quite a few requests for different locations that we might visit, and we are, as I said earlier, carrying on our unaccompanied site inspections. And we haven't yet come to a view about accompanied site inspections, but we will reach a view on that, and we will be publishing our confirmed itinerary on the 26th of June, which is set out on the timetable. So we're still in deliberation. Okay, so let me just ask the applicant, now we understand, of course, that you have assessed dark skies in APP 59 under tourism and nighttime photography and visualizations, and the conclusion, and subject to you confirming differently, was that whilst the array would be visible at night, it would not intrude on views of stars or dark skies, as it wouldn't impede overhead views, and turbines would be visible on the horizon. And that you have made a number of commitments in relation to dark skies. Is that a fair summary of quite an extensive commentary, but in a nutshell?
Simon Martin for the applicant. Yes, I think in a nutshell that's a fair summary. And just to draw out the distinction really between the significant visual effects on offshore views, looking out to the lights and seeing them on the horizon from the east coast in the sea, compared to what we're saying is non-significant effects in terms of effects on dark skies above the viewer. I suppose the aviation and marine navigational lights are relatively low to the horizon. They don't extend high into the sky, so it really does limit the amount of night sky that's impeded, and I think we expect to have limited influence really in terms of views of the stars and the northern lights in the night sky. I think the dark skies sites were mentioned previously, and fundamentally the purpose of those is to be able to go and view the Milky Way and clear conditions to see stars, and appreciate the dark skies, and those conditions will, in our view, can continue to be experienced regardless of the presence of the aviation and marine navigation lights out to sea low on the horizon.
And is there at any point a situation where there, in your view, there would be an effect on dark skies, any level of lighting where there would be an effect on dark skies?
Simon Martin for the applicant. So we've assessed the worst case scenario in the impact assessment, and one of the key findings of that was that they wouldn't reduce in what we call obtrusive light through sky glow and reflective light, and so I suppose there may be an effect in the sense that you may see the lights in the context of dark skies and the northern lights potentially to the north, but with the wind farm off to the east. So it may be seen in the context, but not resulting in significant effects on those dark skies and one's ability to appreciate the dark skies above. It's really trying to draw out that distinction, I think, between the effect of offshore views of the lights and appreciation of dark skies.
And I do see hands, but let me just finish my train of thought, please. So in other dark sky reserves, there are lighting guidelines. I'm thinking, for example, North York Moors uses warmer lights under 3000 K to reduce harmful blue light. Is there anything that you have put forward in terms of lighting guidelines that we should be drawing on in dark sky reserves?
Amy Sterling on behalf of the applicant. There is no proposed lighting mitigation for dark sky specifically. However, the applicant does have various proposed nighttime lighting mitigations. So perhaps Mr. Martin can speak you through those, but they're not dark sky specific.
Should there be?
Amy Sterling on behalf of the applicant. I would suggest not, because our assessment is that there are no significant effects.
And we also understand that lighting intensity levels would be determined by visibility levels. I think 2000 candela in visibility of less than 5K would be dimmed to 200 in visibility of more than 5K. Is that correct? And if so, how can we be confident that those lighting levels would be dimmed?
Simon Martin for the applicant. So the applicant's updated its outline aids to navigation plan at deadline 2 to clarify this point about mitigation and the dimming of the lights. The applicant proposes to operate the aviation lighting in line with the UK best practice, which provides for that reduction in light intensity that you've referred to from 2000 to 200 candela, and that's when visibility is in all directions from every wind turbine is more than 5 kilometres, based on recordings on the visibility meters on peripheral wind turbines. So the applicant's exploring that technical and regulatory feasibility currently of this dimming with the Isle of Man CAA currently. The impact assessment is based on a worst case of 2,000 candela lighting, and so we've assessed the worst case in the assessment, but there's potential for that intensity of those lights to be lesser in reality should those measures go forward.
And so that's feeling a bit like maybe perhaps if it all allows, so I think what the XP would be looking for is more certainty than that, and appreciating we're kind of stretching into something from onshore to actually what's on the turbines. So my sense is, well, my question is, would it be controlled by sensors firstly, and how can we be confident that that proposition is doable and that the lighting levels could be dimmed or would be dimmed? I'm kind of conscious as it's stretching into sort of aviation areas, but nonetheless it has a bearing on visibility from the land.
Ms. Stilling, on behalf of the applicant, I just want to be clear that the applicant's position is that the current regulatory environment within the Isle of Man does not permit them to reduce from 2,000 to 200. So the application is based on the worst case 2,000. However, the aids to navigation plan commits the applicant to further explore this with the Isle of Man CA to seek to reduce to 200. So I would suggest that you can't place weight on the 200 because there is no regulatory certainty at this point in time that could come forward. Therefore, the nighttime views are the views and the visualisations and the other assessment tools that form the SLVIA, which are based on 2,000 candela.
Yeah, it's a point well made. Can we take that further during the course of an examination? Maybe that's a conversation for Mr. Smith and the panel to have, and come back to you on, probably for you to think about. I don't disagree with what you're saying, but I'm just want to think about that.
Yeah, no, I think the best way to deal with that will be to kind of put it into our kind of panel room deliberations and then resolve the question of whether we need to bring something out further in writing or possibly at subsequent hearing events. But there is a clear interface between the aviation position and the consequential effects in SLVI terms, so we will have that conversation.
Okay. Yes.
Amy Stilling on behalf of the applicant. We have another similar scenario, but it would be useful in terms of aircraft detection lighting systems and what we might be able to do around those. So if I think it would be an opportune time for Mr. Martin to just explain our thought process on ADLS, because it is a related topic that will inform your deliberations on this matter, I would suggest. I'll pass to Mr. Martin.
Yeah, sure.
Thanks. Simon Martin for the applicant. So yeah, ADLS is aircraft detection lighting system. So it's for wind farms are a safety technology that allow the turbine lights to activate when aircraft are in the vicinity and fly into a zone of airspace around the wind farm. Those systems use radar or transponder technology to monitor the airspace, and effectively the lights can be switched off when aircraft with a transponder fly into that airspace. So switched on, sorry. So yeah, currently the applicant's undertaking work to understand how ADLS could be implemented, potentially as a radar-based system, and reviewing air traffic volumes around the site to understand more in terms of how frequently ADLS would reduce the the frequency with which lights would come on. But in our experience, the use of those kind of systems has the potential to reduce effect levels to non-significant effects due to the very small frequency of time, small amount of time that the lights would actually come on. And that's been a finding of on a number of the onshore wind farm inquiries in Scotland, where this matter has been given more consideration. And I think Nature Scott have taken that position on other projects, that significant effects would likely be reduced to non-significant levels with the use of this kind of system.
Can I just check that point? Because obviously in a terrestrial environment, what you don't have is a safety consideration in terms of traffic movements at base level. Whereas around the foundations of an offshore wind farm, prospectively there are, for example, sustained fisheries shipping movements at beneath platform level or foundation level, and there's a slightly tense trade-off then between further extension of protection to landscape, seascape, landscape and visual values, which indicate in favour of switching lights off at night, and safe ongoing economic activity around, for example, fishing vessel movement, which broadly tend to indicate maintaining at least foundation level, platform level lighting at night. Now, there's a question then about the brightness that's required, but that it is not a simple trade-off in the way that it maybe is in a terrestrial wind farm.
Amy Sterling on behalf of the applicant. Sorry, just to be clear, this is the aviation lighting, not the marine navigational lighting. The marine navigational lighting would remain on. So the position would be, if such a system were implemented, that the aviation lighting would be off as a standard position during night time, and then would activate and come on when an aircraft was in the vicinity. The work that the applicant is doing is discussing this with the Isle of Man CEA as to whether or not that can be accommodated within the regulatory environment, and also undertaking work to understand in that environment how often the aviation lighting system would be triggered. It's helpful, of course, that the airports in the vicinity don't tend to run flights overnight, for example, so we would hope and expect that the lights would remain off for the majority of the time. There is some sources that suggest the lights could be off for up to 95% of the time, but that isn't modelled at this particular location. So that's the work that's ongoing at the moment. But likewise, for the purposes of this application, and the reason I thought it was useful to mention it in the context of the Candela lighting, is that this is a commitment to explore, essentially, that the applicant intends to put in its aids to navigation plan, but the current regulatory environment doesn't enable it. So it could only be a commitment to seek to explore it further, and the worst case scenario would remain that the 2000 Candela lights remain all night.
I think what would be helpful is a post-hearing note just to summarise this sort of discussion and the emerging technology and where you are on it, and then I think we'll chew it over as well ourselves, if that would be helpful. And now I'm mindful that lunch is at 1. However, and it's now 10 past. There's a couple of hands I wanted to go to on this dark skies item, please, if you would still like to make representations, and if so, can you make yourself known to the microphone person? Or if not, your lunch is more pressing, then Mr. Anthon.
Yeah, so just to, Madam Chair, just to get my head around the understanding is that currently there are no allowance in Manx legislation for the candela of the lighting to be any dimmer than the maximum, which is 2000, if I understand it correctly. So although we were under the understanding, some of us, that we could, that possibly these lights could be dimmed at certain times, that was actually not true. And currently the regulation is that they have to be on at all times, which obviously makes it even more important that you do see through those 3D goggles, I'd say, because it was quite a shocking sight. And I can obviously understand that that was when there was 100 turbines there, but still at 87, there's still a good number of them there to give you a pretty good idea of what we can all expect on the East Coast should this development go ahead. When we were just talking about how these lights won't affect the horizon, because obviously the Astronomical Society on the Isle of Man have said that they don't view stars from that part of the horizon. It's much more further up than the whatever degrees it is that these turbines are at. My colleague here, Jamie Smith, has emailed actually this to the MEMA thing, and maybe you can look at it after lunch or over lunch. A fantastic picture of himself and his family on New Year's Eve on Mackled Head with the Aurora Borealis right on the horizon, and the absolutely beautiful sight of that, which he's emailed to MEMA for you to look at. So with the turbines on the horizon, that would definitely have affected that site. So I just want to make you aware that, you know, we do see these absolutely fabulous sites sometime living down by the coast that would obviously be affected and destroyed by these turbines, and also they're all night as it currently stands, full power lighting. Thank you.
Yes, thank you. And there was another hand I recall.
You, Ian.
Oh yeah, thank you.
Ian Strafford. It was really just to probably re-emphasise the point that I think Richard's now just made, but in the assessment I notice a continual reference for dark skies, that it's dark skies overhead. I would perhaps contend that dark skies are not directly above, but they are horizon to horizon. And there's an awful lot of people, when they're looking at planets rising and so on and so forth, that this would interfere with. I recognise in terms of what the applicant said with respect to their current assessment, says there is no significant effect, therefore there's no need to do anything else. I would just respectfully ask that maybe reconsider whether the scope has been properly covered, and therefore there may be effects, there may be ALARP aspects that could be covered, which have been discussed and which would be very welcomed. Thank you.
Yes, thank you for those representations. Applicant, did you want to come back on anything there? And then a quick question, presumably you're in discussion with MOD about some of these lighting changes. So 2 points. Would you like to come back on those two representations, and then MOD and what discussions you have or aren't having?
Amy Sterling on behalf of the applicant. Whilst Mr Martin just gathers his thoughts, I can confirm we are in discussions with the MOD in relation to all of these proposed mitigations and the updates to the aids to navigation plan.
Simon Martin on behalf of the applicant. I think, yeah, I thought partly in response to those points, I just wanted to make the point in relation to the UNESCO biosphere, which I think recognises the dark skies viewing sites, and it's really, I think, to make the point that there's an international dark skies places programme which defines international dark skies parks. The Isle of Man is not defined as an international dark skies park, but the UNESCO biosphere reserve promotes sort of dark skies initiatives and dark skies interests. I think we recognise that there are I think 26 dark skies discovery sites on the island, and they're promoted for their dark skies values. Ultimately, they were awarded that status on being accessible and free enough from light pollution to get a good view of the stars. And at these sites, the Milky Way is visible to the naked eye. So I think it's just trying to draw that distinction between the effects of the lights of turbines out to sea, which potentially may be seen in the context of ephemeral features like the Northern Lights, which are not always present, and the ability to see and appreciate dark skies from these these recognised points on the island, which will in our view remain regardless of the presence of the wind turbine lights.
Okay, right. I'm going to bring us to a close for lunch, and let's come back at 2:20. Thank you. Welcome back, everybody. And I hope you've had some lunch, maybe got some fresh air. Okay, so now we're turning to item 4C on the agenda. 4C on the agenda, and we are looking at the different designations around the island and what our understanding is of areas of high landscape value and coastal significance, coastal and landscape significance in the Isle of Man. So let's just start with that. So, Mr. Randall, would you mind popping up onto the screen that plan, please? And so, appreciating that this is not that clear, probably for people towards the end of the room, what this map shows is the areas of high landscape value and coastal significance in the Isle of Man. And what I'd like to understand is how much of the Isle of Man is covered by these designations, given that we now have the area plan for the south and the west. Sorry, south and the east. Okay, so I'm just finding my notes. So my understanding is in the north and the west, the AHLV is still in force, as the area plan that went to Tynewold was not approved. And in the south and the east, the plans did receive approval. And in those areas, the AHLV has been replaced with landscape areas and landscape types. And turning to you, Cabinet Office, is that correct understanding?
Good afternoon, Diane Brown on behalf of Planning Policy for Cabinet Office. Yes, that's a correct understanding. The South Plan and the East Plan were both approved by Tynwald, and the landscape character was taken forward into those plans through proposals.
Thank you. And the applicant, turning to you, is that your understanding as well?
Simon Martin for the applicant. That's our understanding as well. Yeah. So.
And the related question, applicant, to that is, does the SLVIA conform with the designations in that assessment?
Simon Martin for the applicant. So yes, it does. The approach taken in the SLVIA is a landscape character-based approach. So we've assessed all of the landscape character areas effectively on the Isle of Man and within the AHLV as it applies to the north and west, and outside of that AHLV where the landscape character area-based policies apply.
And you're certain about that? You're sounding not so certain.
I think if there's any uncertainty there, it was just to, I suppose, there isn't an overall finding, if you like, within the SLVIA chapter in relation to the AHLV. It informs the AHLV designation and its value and the recognition of it as having coastal significance informs the value and the sensitivity that we assessed for all of the constituent landscape character areas along that coastline.
So you haven't considered the AHLV in the south and the east, or you have? I'm just trying to understand that.
We have considered it there in the SLVA chapter. It was we have considered it as part of the assessment as informing the character areas and landscape types that form the areas of landscape within the south and east. So it's recognised as an element that defines value of the landscape in that area.
And yet in the south and the east, they've now been superseded by the area plans. So I'm just trying to understand whether the SLVIA has given weight to the right thing. So if the SLVIA has been based on the AHLV, that wouldn't have been the right designations to be comparing it against.
Simon Martin for the applicant. So the area plans use the 2008 landscape character assessment areas, and we've assessed those landscape character assessment areas within the south and the east.
Sorry, can I just see what's going on with the live stream?
Can we just confirm, do we have internet connectivity? Not currently. Okay, so those outside the room are no longer with us. Just maybe pause for... The live stream's still on. It's just Teams. Ah, right.
Yeah, shall we adjourn for... Are we back online? Shall we adjourn and come back in 5 minutes, or when you tell us it's sorted? Let's do that.
Yeah.
We are back. I don't see anybody online, that's why I'm wondering. Let's take down the map, and then can I just ask those who are online to... let's just see if we can see them. Mr. Garden, can you hear and see us, and have you been following us since we returned after lunch? Right, it's not so clear that Mr. Garden... Ah, there you are. Mr. Garden, can you see and hear us? We can't hear you. And what about DEFRA's expert technical advisor? Can you hear us, Mr.
I can now, yes. It's yes, Oliver Brown. At times, though.
Right, have we now got contact with both Mr. Brown and Mr. Garden? And is the live stream working? Oh.
I can hear and see the room and hear Mr. Brown as well.
Yeah, same here.
Great. We'll press on then. So let me try this question one more time. Given that the area plans now have replaced a HLV in the south and the east, should the SLVIA be amended to correctly refer to what is AHLV or not? You know what, I'm going to let you think about that. I'm going to suggest we have recess for 5 minutes or until you tell us it's sorted. So let me leave that question with you, and we'll head out and come back in when the tech's sorted.
test. Turn it off through the speakers. Just this on the mic. Well, bear in mind you'll be on the actual live stream. Right, okay, well, I don't even know if it's coming through to me. I don't think it's coming through, Joe. Pardon? I don't know if it's coming. Yeah, test, test, test.
We'll restart, and it's 14:50. So let's just return to that question. Maybe I'll frame it slightly differently. So at deadline 3, we received a submission from the Cabinet Office, which was quite illuminating in terms of the AHLV designation and the area plans and what took primacy. And we've discussed that this morning with Ms. Newton as well. So my question really was, what, in terms of the SLVIA, did you refer to? Did you take into account the AHLV? And if so, is there something that we should be looking at differently in terms of the SLVIA? And was that the Cabinet Office position clear to you? And is it all fine?
Amy Sterling on behalf of the applicant. If I can, I'll just give an overview, then pass it to Mr. Martin for any technical specifics. So what the SLVIA assessment does is that it assesses landscape character types and landscape areas as set out in the Isle of Man Landscape Character Assessment 2008. Some of those landscape character types and some of those landscape character areas are in the AHLV. Where they are, the AHLV status was considered in terms of the value. So the AHLV wasn't assessed as a receptor in its own right. It was considered within the context of the value of the landscape character types and landscape character areas as identified within that character assessment. The applicant appreciates now that the clarity that's been provided that the AHLV status doesn't apply to the east and south, and the area plan for the south and area plan for the east does. Those area plans are also based on the landscape character types and the landscape character assessments, so the spatial extent of any of the assessments wouldn't have to change. The only thing that we could do a sensitivity test perhaps on is the value associated, because we have associated the value in the east and the south where it was previously considered to be within the AHLV as having a particularly high value associated with that designation. That designation would now change to being the area plan for the east or the area plan for the south.
But just to nail the point, at the risk of going over it too many times, the AHLV does not apply in the south and the east. Do we agree on that?
Amy Sterling on behalf of the applicant, yes.
Great, thank you. And your colleague, I think, wanted to explain a little bit further.
Yeah, just to pick up on that, really, that I think that is probably the key thing in terms of what possible updates may be made. It would be looking at sensitivity value, because we may need to look at the degree to which areas within the south and the east no longer being covered by the AHLV, whether that may influence assessments of value which form part of our assessments of sensitivity. The assessments of sensitivity are also derived from susceptibility of those areas to the offshore wind farm. So ultimately, I suppose we've assessed a worst case in the SLVI chapter. If anything, it would be whether some of those sensitivities to the south and east may be lower. Now we have the sort of a full clarification and understanding of the status of the AHLV in those areas to the south and east.
Well, indeed. So a sensitivity test is what needs to be done. I agree. If we could have that as an action, that would be good. And then we actually know we have a more informed understanding of what we're discussing, because that feels a bit like ifs and buts and maybes. Thank you. And Dafa, did you want to comment at this point?
Ken Mill, representing DEFA. Perhaps I could pass over to our external advisor, Mr. Brown.
Thank you. Just checking everybody can hear me after the technical glitch.
Yeah, we can hear you fine.
So yeah, excellent. Thank you. So good afternoon. It's Oliver Brown. I'm a chartered landscape architect providing technical support to DEFA in relation to landscape and visual matters. Just for a little bit of context, if I may, and just to manage expectations, my involvement in the project has primarily consisted of a high-level review of the SLVIA, and so where matters sort of move beyond the scope of that, we may consider essentially supplementing after the hearing in terms of written form, if that's okay. In regards to DHLV and the value of those landscapes, I think what the applicants explained there just seems a sensible approach. The assessment of the value of a landscape, just for a landscape to be valued, doesn't necessarily have to be designated, and the Institute technical guidance on valued landscapes essentially covers this. And yeah, we promote a character area assessment of the value of that landscape, and it sounds like one of the actions is going to be a review of the sensitivity with some of the recent information that's come forward.
And then what we would ask is that DEFRA, of course, looks at that submission that comes in at deadline 4. Mr. Randall, I have noticed that the captions aren't appearing. And just while we're looking at the captions and in the interest of continuing with progress, DEFRA, I've also wanted just to ask about the statement of common ground with the applicant, for both, question really for both of you. The statement of common ground does not include LVIA as a topic heading. I just want to understand if that position is going to have changed by deadline 4. I think that's when the updated statements of common ground are due in. Yes.
Amy Sterling on behalf of the applicant. Yes, that's because the applicant was previously informed by DEFRA that their statutory role didn't extend to SLVIA. However, we understand that position has now changed, so we'd be happy to capture this topic in future iterations.
Yes, I'd understood that probably to be the case. Mr. Brown for DEFRA.
I've got nothing further to add. Sorry, was there a question in regards to the statement of common ground?
So there is a statement of common ground, and Mr. Brown, perhaps if it's not you, then your colleagues here in the room might be able to reply, but Mr. Milne is going to reply. Mr. Milne, just for Mr. Brown's benefit, the question was, there is a statement of common ground underway with the applicant, and SLVIA is not a topic, and will it be so by deadline 4?
Ken Milne on behalf of DEFRA. Yes, we previously provided comments on the sort of high-level technical review of the EIA, and our intention will be that will be in the statement of common ground going forward.
Great, thank you. And so if I may turn back to the applicant, can you provide a summary of the approach you have taken to the SLVIA and the areas where you have reached a conclusion of LSE?
Simon Martin for the applicant. So in terms of, are you talking about in terms of seascape, landscape receptors or visual receptors? Here, if I can just ask a clarification there.
Visual receptors, please.
Yeah, so we undertook, obviously, we went through a scoping process as part of the early stages of the project and consultation. We scoped in, assess receptors that have potential for likely significant effects. Our assessment focused on representative viewpoints on the Isle of Man, so those representative viewpoints are primarily along the eastern seaboard, key receptors, visual receptors along the coastline, picking up on representative locations where there is potential for significant effects based on our assessments, which combine assessments of visual sensitivity and visual magnitude or magnitude of change to arrive at assessments of significance. We've used a number of tools to inform that. So we used zone of theoretical visibility modelling, visual influence modelling, wirelines, photomontage visualizations to inform those assessments, as well as surveys and photography on site. And then we used those, I suppose, the visual aspects of our assessments inform our assessments on sort of interrelated effects on seascape character and coastal character along the coastline.
And in relation to the landscape receptors, just an overview of what your process has been?
Again, so we use the ZTV initially to determine landscape areas which are within the zone of visual influence of the project. Any of the landscape areas that are outside of the zone of visibility would be scoped out as having no likely significant effects, because there's no visibility and no potential to change the perceived characteristics and qualities of those landscapes. And then once we've determined those areas that have no potential for LSE outside of the ZTV, we undertake sort of detailed written assessment based on field surveys from each landscape character area, assessing the sensitivity to change based on the value and susceptibility and the magnitude of change arising from the proposed development. And all of those seascape character areas which sort of follow the eastern coastline that could be significantly affected are assessed in detail in the SLVIA chapter, in EIS chapter 8.
Okay. And DEFRA, did you have any disagreement with any of the conclusions in the SLVIA?
I will hand over to my colleague, Mr. Brown, to answer that one. Thank you.
Thank you. Oliver Brown, representing DEFRA. I think looking at high level, the submitted SLVIA is substantial and well put together document. I don't think we've got any issues in terms of the technical points. Obviously, it clearly identifies a number of significant adverse seascape, landscape and visual effects associated with the development. I think in terms of commenting on specifics in terms of identified receptors and the assessment of the significance of effect, it probably moves a little bit beyond the scope of the high-level review that we've undertaken. So I wouldn't want to sort of overstate the position at this stage. However, we can, probably through the statement of common ground, probably the most sensible vehicle to do this. We'll be able to identify where there are any areas of disagreement in terms of the actual findings of the assessment.
And Mr. Smith.
Yep, just before we leave this point, and I'm very conscious that before we step too far into methodology, there was just a remaining policy point that I wanted to test between both the applicant and DEFRA. And being alive to the conversation that we've had previously about the prospective engagement of MPS, and particularly MPS EN1, the first question that I wanted to put, and it's probably fairly first best put to DEFRA and then to the applicant, is whether in relation to the specific task of considering policy compliance in terms of SLVIA effects, do we envision that there is sufficiently clear, present and applicable Manx policy, particularly strategic plan policy, embroidered by the area plans as necessary and by the residual effect potentially of the significant landscape value study, the remaining study in the areas where there are no local plan, well, no area plans. Do we think there's enough of a policy framework there to enable us to navigate all of this without having to resort to the framework provided by MPS EN1? So that's my first question.
Ken Milne, on behalf of DEFA, I'm going to have to take that one away to respond in writing, if that's okay.
Okay. And we'll pick that as an action, and I think by deadline 4, if we can. Notwithstanding that you don't have DEFA's position on it, what's the applicant's in principle view, or do you want to return in writing, Ms. Sterling?
Amy Sterling, on behalf of the applicant, I would suggest the position is similar to one that we discussed earlier. The area plans are also prepared under the Town and Country Planning Act 1999, therefore are generally terrestrial planning policy. They do, however, identify qualities and characteristics of the landscape under the landscape character assessment, which does help as a useful assessment tool. However, they were not designed for the assessment of offshore wind projects. Therefore, whilst I suggest that there's sufficient characteristics available about these landscape character areas to allow the assessment to be undertaken, the methodology for that assessment and the role that offshore wind has to play is usefully informed by the MPS.
Okay, so we understand your position on that. If we then step down to the next level of detail, obviously then you start to look at what, starting point MPS EN1, but then EN3, but critically here EN1 says about the consideration of landscape matters. And I'm looking specifically at the paragraphs from 5, 10, 9 in NPS EN1. And you'll be alive to the fact that those paragraphs essentially set landscapes within a large nation-state, multi-tier governmental hierarchy. So it starts off with the national tier of statutorily designated landscapes, national parks and national landscapes in England and Wales, and then it steps down through heritage coasts, and then it moves on to 5, 10, 12, outside nationally designated areas. There are landscapes that may be highly valued locally, and then it sets a policy framework for those. And clearly, the policy consequences of those national versus semi-national heritage coast versus locally valued are very different. And so if we find ourselves in the policy environment set by the EN suite, there is then an obvious logical question, which is, are all of the landscape policies and designations emerging within the Isle of Man framework to be deemed to be at the national tier, qua MPS EN1, paragraph 5.10.9, or something beneath that, for example, such as equivalent to heritage coast under 5.10.10, or are they in the outside nationally designated areas category under 5.10.12? Now, recognising what DEFA has already said, which is it wants to take this on advice, if you just take a note of that, and we'll read your position on that at deadline 4. But Ms. Sterling, if you and your team are in principle able to answer that now, that would help.
Amy Sterling, on behalf of the applicant. Yes, the applicant's position is that there's something less than a national designation, because for the area of high landscape value, for example, there are no supporting citations or associated evidence as to why it was designated. The boundaries are not well defined. They're shown only indicatively in a diagrammatic way in the key diagram, and they don't form part of any sort of approved development plan. I will have to take away what our position is in terms of these area plans, which we now understand replace the area of high landscape value in the east and the south. The applicant...
And sorry to cut you there, but specifically taking into account what seemed to be the agreement on policy standing this morning, namely that there are the strategic plan is the starting point as a statutory plan, that subject to the provision on general conformity, which where an area plan has been made is therefore complied with, you're then at the level where the area plan in detailed terms can set out policy that, because it's newer than the strategic plan, is the policy that applies.
Amy Sterling on behalf of the applicant. Yes, appreciated, sir, but then there's a step below the area plan, because those then rely on landscape areas as identified within the landscape character assessment, which is what the applicant has assessed again. So there's not an area within the area plan that is just assessed. They're then subdivided again, which is where I think it's not entirely clear whether it's local, regional or national. So I do think that's something we'll have to revisit.
I think there might even be value in a kind of roundtable huddle, frankly, where the applicant has a conversation with DEFRA on this point, because at the end of the day, I think there is a distinct hazard in our considerations here, which would be the uncareful application of an English and Welsh hierarchical framework, which was never designed to deal with a single unitary nation like the Isle of Man, in circumstances where nevertheless we may be, in the terms that you describe, necessarily having to apply the EN suite as best we can. And I think if we were at least in a world where there was some measure of shared understanding, at least we knew what the scope of dispute is, maybe, on the question of where we sit in terms of national, subnational, stroke, regional or local in the EN suite, and therefore what that means. That would be a really, really good starting point. Yes, I will return to Ms. Brown.
Diane Brown.
So there are two people with your hands up. I've noticed, so you don't need to keep your hands up.
Sorry, Diane Brown for Planning Policy for Cabinet Office. Certainly, if there's any huddle involved between the applicant and DEFRA, certainly Cabinet Office would offer to be part of that as well. Just to clarify, yes, the areas of high landscape value, they have first appeared on the 1982 plan. That plan was never digitised, so whenever we have had to reproduce that plan, we've had to take the best representation we can do in digitising that 1982 plan, which came in one solid plan, which you have to unfold. That was the scale it was produced at. I think there is no citations for that, but I think that historically the areas of high landscape value, they go back to probably the start of the early 70s from anecdotal knowledge within the department. I think in terms of where we're at and what status, what takes precedent, what has the status, it's important to note that in the area plan for the east and the area plan for the south, we did take on board the 2008 landscape character assessment. That was translated into a series of proposals which were set out in quite a bit of detail actually in the area plan. So I don't want us to miss the point that areas of high landscape value they don't exist anymore, but in terms of the detailed work that went into landscape character assessments, they've been carried through to the area plans. So it's worth making sure that those plans are sort of looked at in detail as well. Thank you. I think that's all for now.
Thank you very much. Well, I've put my question to, obviously, applicant and government parties. Ms. Fernandez, it's your hearing, and we do have hands. Would you want to take the next section, or would you like me to finish the point with the hands that we had in the room?
Without knowing why the hands are in the room, that's a difficult question to answer. And three hands in the room. So, are your questions related to this specific point? Yes. Right, let's take them. Mr. Strafford first, please.
Thank you very much, Ian Strafford, resident of Laxey. In listening to the discussion, where I think it's important for us to understand whether these areas of high landscape value are national or regional, etc., and the point, Mr. Smith, I think you were trying to establish. I think you made a very valid point, which is trying to compare the Isle of Man designations with the UK and so on is difficult to do. But the point I would like to make is, as we've made many times before, the Isle of Man is a UNESCO Biosphere Whole Nation designated status, and a key part of that designation is its landscape and the value of its landscape. It's not separated into individual parts, etc. The biosphere status is for the entirety of the Isle of Man and the landscape that's represented in there. So that might be a point worthy of consideration when the examining board are coming to a conclusion as what you believe is the appropriate designation and hence the appropriate applicable planning policies. Thank you.
Thank you. Ms. Newton.
Thank you. I just wanted to draw attention to the fact that I submitted Circular 179, which does carry some explanation of the areas of high landscape value and Senate significance. And it says the intention of the board, which was the then local government board, is to adopt a policy of creating, preserving a pleasant, safe and efficient environment by optimising the use of island resources. In this context, the term resources is used in the widest sense to include aesthetic resources such as the beauty of the coast and the countryside and the quality of existing buildings, etc. Other natural resources are also a valid consideration, and to this end, nature conservancy is also of significance. I've taken the attitude that the Isle of Man is a nation in its own right. It uses its own definitions. It's not bound by Scottish ones or English ones. Scottish ones are different from English ones. We should be using the AHLVSS where it's still applicable in Mackle and the North as being a national designation. There's parts of the islands are in, parts are out. We can't afford to have little designations within that. We do in the area plan for the east and south, which have taken on the 2008 landscape characteristics. I don't think they were asked to come out with specific higher quality areas than others, but what they have done in those plans is identify particular areas of importance, which again I've copied the references in my earlier submissions, where they are relevant to the coast between Langness and, in this case, it's Douglas, which has its own plan, or had its own plan, and Onken. Laxey, of course, is in the area plan for the east, and again, it has its own specific characteristics which are identified in the area plan for the east. But it should not be a case of totally trying to say we have to have national parks or national scenic areas, etc., in accordance with the MPS N3 designations. We have our own, and that's what should be most applicable.
Yes, thank you for that. And just turning to yourself as well. Yeah, the microphone's just coming.
Well, thank you. It's really just to
sorry, if you...
Miss Farragher, Marinda Farragher. The area high landscape value, you will know, still extends around the whole what was Mackle parish. I think where's the cut-off for the eastern area plan? Is it around the Doon Glen area north? Is it? Yeah. So that whole area, that whole coastline there is still at HLV. Mackle Head. I was there. I chaired the meeting when the conservation area was established, one of the first conservation areas on the island in 1991. So if you need any information on that, if that holds any weight in this inquiry, I've found some old minutes. I've got the notes of the meeting, if that's any use to you. Very, very, very sensitive area.
Thank you. And if you, I think Ms. Newton just wanted to come back on a point. If you would put those in as a post-hearing submission, then that's helpful. Thank you. And Ms. Newton as well.
Sorry, going back to the practical side, I've no problem with the description of the areas as given by the applicant in terms of what they contain. What I do have a problem is with, again, the applicant having denigrated site visits to a lot of the sites. And they have said, for instance, that Doon Glen and Corney Glen shouldn't be visited because they have the same view out as Laxey Bay. Sorry, Laxey Bay is an extremely wide open area. Doon Glen and Corney have enclosed areas, so the proposal for the wind turbines will have a completely different perspective in those areas from that in Laxey Bay. And therefore, you shouldn't just eradicate certain sites from site visits because of, I don't know why they have done this, but they seem to be contradicting their own statement because they obviously identify the separate character of Doon and Corney Glens from Laxey within their own statements.
And we will be coming back to that slightly later in the agenda today.
Right.
Okay, so if I might now ask the Cabinet Office and DEFRA just to respond to what they've heard, and then I will ask the applicant in terms of what I would paraphrase is the Isle of Man is its own place, and while we're looking to the UK in terms of, you know, is it a national, is it a local, is it a regional, the Isle of Man's starting point is different. Just be interested to understand your responses to those comments from the principal stakeholders that have spoken.
I'll go first. My name's Diane Brown. I'm speaking on behalf of the Planning Policy for Cabinet Office. I think it's just to point out that this process sort of finds us in a state of transition really between an old system of areas of high landscape value and where we want to get to next. So we had some feedback from the inspector who did the area plan for the east. And at that time, we weren't in a position, weren't able to be very precise about those boundaries for the areas of high landscape value. So it's better to, what we decided at that point was to do an island-wide study that would not only refresh the 2008 landscape character assessment, but also look at the potential for sort of national designations. So the methodology for that 2025 landscape character assessment was looked at very carefully and does sort of follow the methodology that the UK would approach for sort of national landscapes. So we are trying to, I mean, if the area plan for the North and West had been approved, we would have been much more of a level playing field, and we would have been here talking today about areas of high landscape value in a historical context. And you know that was a policy that was applied to plans and planning applications for decades, and it served its purpose. But we're trying to get to a point where we're looking in detail a bit more for our local areas, and so we've got the whole breadth of local area and areas and types, and those national designations as well. So just to point out, we can if it would help the examining board, provide any overlap mapping, because we've done it ourselves already to look at how do the areas of high landscape value overlap with the area plans, and again how what the overlap is between sort of the national designations that we're sort of carrying forward through the strategic plan process. So if that would be helpful, then we can certainly do that.
I mean, that would certainly be helpful. I've had a go by hand, and obviously that's my rather poor attempt at it. But just to follow up on something you said, the examination is, however, taking place at this moment of time, and whilst that, accepting that we may be in a transitional state, or you may be at the time by which we are likely to have closed the examination, this transitional state that we are now trying to understand will still be the case. It may be, if we were in a year's time, it might not be the case. Nonetheless, it is the case. So whilst understanding the direction of travel, and that you've helpfully set out, we need to still mark down what it is that is today's reality. But to go back to your point, the mapping would be helpful. And I'd like to go on to the candidate special landscape areas, which again would be helpful to map in, but let's pick that up in just a moment.
Okay, thank you.
DEFA, please.
Ken Milne, representing DEFA. I have nothing further to add at this point. We'll come back obviously with the AHLV and the national designation when we come back to deadline 4 with our comments. Thank you.
And the applicant.
Amy Sterling on behalf of the applicant. Just a few sort of brief observations. Firstly, ensure everyone, will encourage everyone, including ourselves, to keep distinct what is a receptor and what is a planning policy. The receptors which have been assessed are the landscape character types and the landscape areas which are set out in the Landscape Character Assessment 2008. There is no single Isle of Man landscape area as in the Isle of Man's government's own planning policy. Some of those landscape types and some of those landscape areas fall within an area of high landscape value. Some of them fall within the area plan for the east and some fall within the area plan for the south. The action I think we've all taken away is to review the consequences of, if it falls within an area of high landscape value, what is the applicable planning policy, and does it differ between national, regional or local in terms of the significance of the effect, and likewise for the area plan east and the area plan south.
Thank you.
Sorry, hi. I had a different set of questions, if that's all right. Not related to policy, well, quasi-related to policy, I guess. I just, it was about your application of sensitivity and magnitude and how you looked at that within the context of the Isle of Man. I've done the environmental hearing and you've used this phrase uniquely Manx and how have you applied it to the assessment. So I just wondered in terms of your, well, maybe your visual's a better example rather than the landscape, if that's all right, if you don't mind. So in terms of residential people who live on the island, I'm assuming they're high sensitivity because they live there and they're looking out on this view. So how have you applied sensitivity to tourists driving past that view, walkers driving past that view, mobile people? Are they medium or low in comparison to the high for the residential?
Simon Martin for the applicant. So we, very much kind of followed the Landscape Institute's guidelines on assessing sensitivity, which gives guidance as to which different groups of people, different groups of receptors, and how sensitive they are to.
That's the English Landscape Institute.
It's
UK.
It's the UK Landscape Institute, yeah. So that's they sort of author the kind of guidance that we landscape practitioners follow on landscape visual impact assessment.
So I'm assuming you've been on site and you've done the site visits and investigations. So I'm just asking if
so it's
any adjustments been applied to the visual impacts on the Isle of Man as opposed to the stand, because you could have the same assessment in London. And I think the scale's slightly different in terms of what people see if you're looking at appreciating a landscape and something visual. So I just wondered if you'd applied anything different to the Isle of Man, any adaptation. I think maybe I could refer to, so the protected species assessment, for example, applies an elevated sensitivity to protected species when it assesses them. So I just wondered if you'd had any sort of thought process, because if you look at the Isle of Man, the views, you've got a tourist walking past, but given the array is almost in your description yesterday, half the island, if you've got a tourist walking from north to south or south to north or driving, they're going to be experiencing that view for most of their journey, I think. So I just, does that make sense?
Simon Martin for the applicant. That makes sense. I mean, it has been the sensitivity to change value and susceptibility of receptors on the Isle of Man has been assessed based on recognised guidance, but in the context of the Isle of Man and the specific receptors that exist here.
I wondered if, could I have my colleague a moment, sorry. So, So you said you've assessed it and you've taken that into consideration against the Institute's guidelines. So would it be possible to do a short note on how you've done that, taking into consideration for visual, this is the sensitivity applied to the different sorts of visual receptors?
Simon Martin for the applicant. That's all set out in our SLVI methodology, which is, I think it's Technical Appendix 8.2.
Okay.
So it's all described there. There's a section in our methodology which sets out how we've looked at sensitivity for, as part of this assessment and the magnitude of change as part of this assessment.
You've just said it uses the standard UK approach. So I'm asking you, and you replied that you'd taken into consideration the Isle of Man context. I'm just asking you if there's something different that you've applied over and above that, and you've just that's not in the assessment, then is what you're saying.
Amy Sterling on behalf of the applicant. I think what Mr. Martin is saying, he's applied the standard guidance, but it takes into account the Isle of Man context because it's applied to the Isle of Man. So the methodology is the same as the Landscape Institute methodology, but it is then applied in an Isle of Man context, which is a necessity for the SLVIA assessment.
Thank you.
Okay, good. Okay, so then I'd now like to look at MPS EN1, which paragraph 5.10.19, which requests that applicants consider landscape and visual matters in the early stages of siting and design, where site choices and the design principles are being established. To what extent, and this is not in relation to the AFL, which we were discussing earlier, this is the next stage, if you like, of the design process. To what extent did effects on the seascape landscape influence a chosen array area or order limits or further design changes? Is there anything in addition to what we were looking at and discussing this morning?
Amy Sterling on behalf of the applicant. It's the same, madam, as we discussed this morning. It was informed through scoping and consultation on the preliminary environmental impact assessment.
Fine, I just wanted to understand and make sure that there was nothing else that we had maybe overlooked. Thank you. And then let's turn to candidate special landscape areas. And again, at deadline 3, Cabinet Office provided a very helpful representation explaining where the candidate special landscape areas were in terms of likely approval or otherwise. And the Cabinet Office question for you, and I probably know what the answer is, but nonetheless I'd like to ask it. Given that the expectation is that these are unlikely to be approved in the strategic plan until late 2027 or early 2028. What, if any, weight should the XB give to the candidate special landscapes in its recommendations on effects on seascape and landscape?
Diane Brown for Planning Policy for Cabinet Office. As I sort of pointed out a little bit earlier, it is an emerging. Well, it is an evidence base. It is, it's sort of credible in that it's sort of taking forward the information and data on our landscape character and our landscape value and how we're going to take that forward into the strategic plan and future planning policies for local areas. So obviously the weight that's attached is a matter for the examining board. the pace that the work is at is obviously at a different stage than this set of hearings and this application. So obviously the Town and Country Planning Act, from a planning point of view, from terrestrial planning, it allows us to consider the development plan or the material considerations. What are the circumstances of whatever it is that we're looking at? So it is, and it would be normal and reasonable to take a published landscape designations report and this landscape character area work as a whole forward as sort of relevant and up-to-date evidence as part of the forward planning for the island. So in that respect, it does have value from a planning policy point of view. From your way of thinking about it, it might have a slightly different take. Having established that the area plans are where they are, and the strategic plan is where that is as well.
Okay, thank you. And applicant, did you wish to come back on that?
Amy Sterling, on behalf of the applicant, I would suggest, as with planning policy, as there's an emerging planning policy, the weight to be attached depends on essentially how far progressed it is towards a final plan. I wasn't entirely clear on the steps for designating these candidate special landscapes and the timescales for those. If they were initial drafts, subject to consultation, that would presumably have less weight than final proposals awaiting formal designation, which may have more weight.
And just picking up that point, the deadline 3 submission was helpful. If I'm thinking about what Ms. Sterling has just said, if there's any more colour you can provide us, either at deadline 4 or at some later stage, as to what the journey will be between now and designation, that would be handy. Thank you. If I can make that as an action, please, for Cabinet Office. Actually, if Cabinet Office, would you mind doing that by deadline 4, and then it enables the applicant to see that as well?
My apologies. Could you repeat that action?
The Cabinet Office are going to look at their deadline 3 submission and to see if there is any further detail in terms of the process by which the candidate special landscapes will be or may be designated. I'm conscious that Garth commissioners, you, I think, wanted to speak on this item, and possibly Mr. Strafford, but perhaps you have spoken. This is in relation to candidate special landscape areas. I don't want to pass on the item without checking. Mr. Strafford.
Ian Strafford, resident of Laxey. Thank you very much for the explanation and the questions being asked by the examining board with respect to visual receptors. Excuse me, put my teeth back in. I'm looking through the particular appendix that's referred to. A couple of questions come to mind. One is, having followed that line of questioning, I'm not sure we actually did get to the answer of whether or not, for example, visitors have been accorded the same level of visual receptor impact as perhaps residents. It is important to recognise that surveys done of tourists coming to this island is that 80% of them come here specifically for those views. This is, as you say, it's not transient passing up the M6 past a wind farm or through Barrow or whatever it might be. This is core to aspects such as the tourism, the value proposition of this island, and indeed is a core government policy to encourage further tourism and grow that business area. I think the other thing which is not immediately obvious within the assessment is recognition that this will be the first of a kind. And that a first-of-a-kind impact is quite often way more significant than an additional extension, a second, and so on, after people have got used to it. So I would ask that the examining body, A, thoroughly, and I'm sure you will, but thoroughly look at these aspects with respect to, as you've been saying, the application of standard methodology and really how has it been applied to be uniquely Manx, to come to that phrase, and the recognition that this would be the first. The scale is huge, and as you rightly point out, for people that tour up and down, whether it's on the steam railway, the electric railway, the tram, walk up the Radnor-Follion, spend hours of their day, what they come for are those views. Thank you.
Yes, thank you, Mr. Strafford. And I'm just conscious of Garth Commissioners. Did you want? Yes, Ms. Farker.
I can say something if it's useful. I mean, I think the applicant mentioned that basically we're already looking at Walney. Certainly, I went out and took some photographs, and difference to our coastline, to be honest. Certainly not aware of it all the time. What else can I say? I mean, Mackled Head, I'm really concerned about. When you looked at I did try to look at all the work that the applicant had done on the in that huge volume. And I think the church tower, Mackled Church Tower, was mentioned as a thing, but basically it's the whole headland and the whole conservation area. So I think I've written in about that. The Manx Electric Railway is very important as a receptor, a visual receptor, all the way. It's almost like the Radnor-Follion you mentioned. Is the whole route from the Point of Ayre down to Langness, and definitely. You know, we don't have caravan parks here. We don't have, when people, it's undeveloped. When people are walking around our coastline, and I work with the Walking Festival as a guide, they're in natural surroundings. So that's that. And the Manx Electric Railway, under the area plan for the east, views from the Manx Electric Railway are to be protected. Transport Policy 3, I looked that up. New development around rail routes should not compromise its attraction as a tourism and leisure facility. There are things on this island to protect what we have and what's special here. And I just want you to be aware of that. Effect on tourism could be particularly massive. I'm not sure that it's been evaluated at all. I can't find any information about that. The visitor economy strategy, it's there to increase the visitors here up between 22 and 23. We've sent that in to you, and one of the unique selling points is the coastline, the countryside, seas, walking, culture and heritage, and all these things are going to be affected by this huge development.
Yes, thank you. So, and I think many of those points are actually coming into the next item, which looks at the effect on visual receptors, people. I know we use visual receptors, but quite often, let's just remember that quite often is just people. Ms. Pownell, can I just ask you to come in here? I think you had a question.
I just, in response to what a member of the public has said, I appreciate you explained that you've taken into consideration the sensitivity of the Isle of Man receptors in your assessment, and you've put those in an appendix, and that you've used the UK legislative guidance. Is it possible to pull out and create a table which explains for each of the receptors how you've considered the Isle of Man in that application of sensitivity? So for the walkers, the drivers, the tourists, the railway, and also how you've applied sensitivity to inland receptors versus coastal. Because in the Isle of Man, they're almost the same thing. Having done our non-accompanied site visits, we've been inland and we've been up high and we've been medium on. It's almost the same. So what sensitivity did you apply for inland views versus coastal, just for example? Is it the same sensitivity rating or different?
Simon Martin on behalf of the applicant. So, yeah, in terms of visual receptors, there's a table in the methodology for the SLVIA, Annex 8.2. So that sets out different sensitivity factors and the various people that may experience different levels of sensitivity.
So how have you applied coastal versus inland views? Sensitivity of those two views, those two view types? Are they both high sensitive or?
Amy Sterling on behalf of the applicant. I think that's perhaps an oversimplification of inland and coastal. If the table, for example, visual sensitivity to change criteria, under susceptibility to change, there are sort of higher values placed on a view that is focused on a specific directional vista.
So sorry
so
to
that's
interrupt.
not.
Could we put the table on the screen? Would that, or can we share? No, we can't share things. We can share things. Do you have the table number so we could just have a look? So you're explaining it.
It's in table 2 of document. What is this?
It's the SLVIA methodology. So it's Annex 8.2.
And so this will tell us how you've applied it to the island, specifically, the different sensitivities.
It's the methodology for this assessment, which is applicable to.
But you said you'd taken into consideration the island sensitivity in your application of sensitivity. You said that's explained in the appendix, so I wanted to understand how that's been applied.
Yeah.
Do you see what
I think when it comes on screen, it might be clearer as to this is the methodology. It is then applied to the specific locations under consideration, which are wholly within the Isle of Man, for the purposes of this discussion.
So this is a standard methodology?
Yes.
Yes, and so my question a while back was, have you amended your methodology to take into consideration the sensitivities for the Isle of Man, because it's a different type of place from, as I said, in the middle of London or something. So, and you said that you had, and it was in the methodology. It's not in the methodology.
Amy Sterling on behalf of the applicant, we didn't say that we'd have a different methodology for the Isle of Man.
You said you'd taken it into consideration.
Of course, because we've applied it to the Isle of Man, madam. So there is a set methodology, which is for the landscape visual impact assessment, which is then applied to the Isle of Man. I would suggest it's an oversimplification to say inland or coastal. So, for example, susceptibility to change, there's a higher value placed if that view is focused on a specific directional vista with notable features of interest in a particular part of that view. That may apply inland or it may apply on the coast. There would be less, for example, if it was open views with no specific point of interest. That doesn't matter whether or not it's on the coast or it's inland. There isn't that binary distinction that you're suggesting.
Okay, my colleague's going to respond, but before I have positive to my colleague, when I asked earlier, your colleague said that you'd used the UK guidance and that you'd taken into consideration the sensitivity of the Isle of Man and that it was in your methodology. I'll hand it to my
Simon
colleague.
Martin for the applicant. I think it's inherent in the assessment, really, that each of the individual receptors that we've looked at, each of the individual viewpoints, we've looked at who is experiencing that view.
I understand, yeah.
Which is people, in the Isle of Man, whether it's a tourist or a resident, experiencing that view in that landscape. So it's kind of inherent and embedded in the assessment.
Inherent in the assessment. Okay,
yeah.
I understand.
What will be helpful, just given the submissions that we've just heard right now, what will be helpful is, this is understood, this is quite a generic methodology, and without going into too much detail, but just do a little bit of signposting through this appendix on how this methodology has been applied to your assessment in the specific context of Isle of Man, and just talk us through it. And this is, of course, for the benefit of the examining body, but it's also for the benefit of people in the room.
Amy Sterling on behalf of the applicant, would you like us, for example, to take a viewpoint and explain how the methodology has been applied to that viewpoint?
So let's do that for one viewpoint today, but I think given the number of different types of receptors that have just been raised, what we might want is potentially 2 or 3 different types of viewpoints and just a canter of how that assessment has taken place, and how one type of viewpoint is different to the other in terms of the application of sensitivity and indeed your conclusions that you have reached.
Can we look at viewpoint that is Muggled Head? I can't remember, it's 17.
Simon Martin for the applicant. Yeah, it's viewpoint 3 at Muggled Head. Yeah. So yeah, we could look at that one. We've just got that one on screen. So in terms of the sensitivity to receptor there, we've identified that as having a high sensitivity. And then within that...
Are we looking at this? I'm not quite sure what you're saying relates to what's on the screen, so maybe just make that a bit more transparent. Can we shrink the page?
Amy Sterling, on behalf of the applicant, apologies. Would you like us to then change documents to show the assessment on screen?
Let's just have this tour quite specific. And so, yeah, if there is a different document that you're referring to where this has been applied, so we will have this open on our screens, and then what we can put up is where you've applied this methodology to that assessment. Sorry, and Ms. Sterling, just remind me what appendix number that was. I've got the EL reference right here.
Amy Sterling, on behalf of the applicant, APP 094 was the methodology.
Yeah.
The assessment itself is in APP 053. So we previously had the methodology on screen. We're now going to switch to the assessment to explain how that methodology has been applied in the assessment.
That's absolutely right, yeah.
Simon Martin for the applicant. So yeah, in terms of viewpoint 3 at Muggled Head, which is just on screen there, you can see the first heading is sensitivity to receptor, and that covers the overall sensitivity that we've ascribed to people at that viewpoint, looking out from Muggled Head, and that's based on us making a judgment or an assessment of the value of the view, which we've ascribed as having a high value, for the reasons set out there, because it's a well-known viewpoint. OS mapping, tourist information signage to that point. It's within the AHLV coastline, implying a higher value to the landscape that we're seeing in that view. So yeah, recognition of the scenic qualities ascribed to the view there. Just looking down, so yeah, bringing in other aspects like cultural recognition of the view, scenic qualities, visited by walkers using the coastal path. So all of those factors in the specific context of that viewpoint on, in the Isle of Man lead to that judgment of high value. And then we combine that with the assessment of susceptibility, which is more about how those people may be liable to changes associated with the project, and what their activities are primarily, I suppose. So in terms of higher sensitivity receptors, higher susceptibility receptors would be people who are whose main attention and interest is on the landscape and on the view and looking at their surroundings, where the view's an intrinsic part of their experience. Might be for this project if it's a headland where you're looking out to sea from that particular location. So we combine those two assessments of value and susceptibility to get the high sensitivity that's recognised for that viewpoint. And I think that will be. Do you want me to go through the actual assessment as well? The magnitude of change is more about.
Let's start. I would suggest let's get into it, and if we want you to canter through something, we'll indicate. Yeah.
So then we combine the sensitivity judgment with the magnitude of change judgment, which we've assessed to be high in that view, based on its a range of factors that we use to evaluate magnitude of change. So its proximity to the viewpoint, at
Okay.
11.6 kilometres there is a particular factor. As a result, it would occupy a very wide and large proportion of the view. So we've actually quantified the lateral spread of the turbines in the field of view there. So it occupies about 60 degrees of the full 360 panorama. And then we've described a bit about the kind of the scale and the apparent height of the turbines in that view and how they may appear. And there's some discussion on other features that are visible. So Walney Extension is referred to there, which is about 31 kilometres away from Mackold Heads, which you can see in very clear visibility, like we've had in the last couple of days. It is quite clear when you get those conditions, but it has I suppose a relatively minor influence in terms of in terms of a comparison to the high magnitude of change that we've identified for Vannin.
Can we move on to paragraph 13, where you're talking about significance of effect? And I think if my colleagues are content, this has given me a sensible overview. If we get some comments from the floor, I'm happy to close that down, Ms. Fernandez, after that.
It's very helpful, thank you.
Yeah.
And we've heard from the principal stakeholders in the room, so.
I just want to get one comment from the principal stakeholder. So let's just talk about significance of effect, and then I can see 2 hands up, I believe, and both, if I'm not mistaken, are from persons who've registered to speak. So just finish off with the significance of effect, and then I have a reasonable overview.
Simon Martin on behalf of the applicant. So the significance effect judgment is then a combination of the sensitivity of the receptors and the magnitude of change that have been assessed above that we've talked through, which we've assessed as being major, correlating the high sensitivity and the high magnitude of change, and then assess effects that are either major or major moderate, and sometimes moderate are significance in EIA terms in our assessment. And there's a description there which provides some of the particular factors that allowed us to arrive at that significance finding. And that tends to be replicated along for all the viewpoint, well, most of the viewpoints along that northwestern corner of the Isle of Man, from around Mackold Head down to Laxey. It's only really dropping in significance. It's only really dropping to the next to sort of major moderates, slightly less at greater distance when you're sort of I think at the very far north or the very southern end of the island at greater distance.
Okay, understood. Now I've got 3 hands. Ms. Fernandez, did you want to get the comments in? Okay, so I think Mr. Strafford was first, and then I think it was yourself, and then I've got one person here.
Thank you very much. Ian Strafford, resident of Laxey. I think the key point that I would just like to draw to the examining board's attention, there's been a lot of discussion here in terms of strategic plan aspects about whether or not we have specific legislation or policies, etc. Excuse me, I'm not a lawyer, associated with the sea or the land, etc. And recognising that the strategic plan is a key vehicle for actually identifying, and I think, as been already stated by a member of the examining board, there really is very little difference between looking from land to sea or sea to land in terms of where you are on the island. The Chapter 6 of the strategic plan is very clear on general policy planning statement, and general policy planning number 2, section E, is very clear in terms of policy planning, which is that nothing should be done that does not affect adversely public views of the sea. So that's very clear in the strategic plan. in terms of placing something within the sea at 6 miles out, it clearly does adversely affect those open sea views. I'm sure there are ways that we could probably talk around this and say whether it applies or not, etc. But the principle within the strategic plan is incredibly clear, that nothing should be done that influences or obstructs those open sea views. And I just want that to be clear. Thank you.
Thank you, Mr. Strafford. We are running extremely behind. I will very quickly take, I'm desperate to respond, but I think it's best to just take comments in and then just, so.
I think you're probably already aware that we're very interested as the commissioners, not just in the visual and the major effect from that receptor angle, but the cultural identities of our places that are so important to the Manx people here. And Mackled Head is associated with our patron saint, Saint Mackled. And we've got Charlie's View, Sir Charles Carouche. His daughter is sitting along here, and she wants to speak about that significant site. You know, I'm willing to go into that more, but I think I've sent in enough. I think you have details about that. You have a lot of details about our cultural identity here. Cashel and Ard is important to the Manx people. You know, I'm going to hand on because you've got a time thing now.
While the microphone's making its way over, I think it's just worth making one point, and that is that I hope it's become clear that what we're trying to do at this hearing is gather evidence as much as we possibly can and points of view around the table, because what we've, where the examining body is coming from is that the conclusion actually nobody disagrees with, that there is a significant adverse effect on the island. The applicant's agreeing with that. The government bodies are agreeing with that, and so are the people. It's actually what you do about it, or indeed how you've arrived at it, is where the points of difference lie. So it is very much this particular receiving environment, the landscape and visual, is one where the examining body will have to take as much evidence as it possibly can and potentially arrive at some judgments when it makes its recommendation. So the purpose of today, it has been very much to take evidence in the policy area, in the methodology area, in the actual effects and you know, and how some of those have underpinned decision making. Yeah. Final point.
Thank you. I would just like to add to that. It's a matter.
Do you introduce yourself, please?
So
Apologies.
Pam Carouche, Mackled resident. I'd just like to add to that, it's not just a matter of whether or not the Isle of Man is affected, but it is how very significantly it is affected. And my question arises from that, and I didn't hear anything, although I may have missed it onto the screen, about from that viewpoint, the wildlife that you can see. Because Mackled Head is a wonderful place to see seals. Very often you can see dolphins or porpoises racing down the Irish Sea in pods, which is a beautiful sight. And of course, there's the bird life around there as well, none of which has been attributed, I don't think, to the view, but it's all part of the view. Thank you.
Yes, thank you. And indeed, we did see plenty of seals when we've been doing some of our unaccompanied site inspections. Okay, I'm going to ask the applicant if you wanted to make any comment. If not, I'm going to suggest we go and have a coffee break.
Amy Sterling on behalf of the applicant. I think the only comment that we would make is that where there was a particular prominence or particular view for viewing wildlife, that would be accounted in the assessment because it takes into account tourist signage, for example. Although, so whilst it wouldn't be explicit, it would be implicit in that assessment methodology. Thank you.
Okay, thank you. So the time is 4:05. I'm going to suggest we come back at 4:20. Thank you all very much. Okay, so you will have, of course, observed that we are not quite perhaps in the agenda where we might have hoped to be by this point of the day. And part of that is because we lost a bit of time on the IT, and part of that is my chairing of today, and we haven't made quite as much progress as I would hope. So what I propose to do is to move the items relating to E, which we 4E, which we have sort of been touching upon in terms of visual receptors and viewpoints, over into written questions, and also F and G, and 4F and 4G. Mind you, I'm mindful that Martin Cubbon and Julia Yates, who I hope are both here, have wanted, and Pankarush had wanted to speak in relation to item 4. I am about to move on to landscape enhancement scheme, so my question to the three of you is, if your questions on item 4 was related to landscape enhancement scheme, then we'll be covering them out. But if they were related to something different, then please can I hear those representations, and then I will move on to landscape enhancement scheme at item 4H. So let me start from the lady on the left, and then on the right from your point of view.
Yes, I want to speak on the onshore seascape effects in the Isle of Man.
And please would you introduce yourself, and then please press on.
My name is Pam Carouche. I am a Maccled resident, and I want to draw attention to the fact that quite recently, in 2025, the landscape character assessment document in the Isle of Man states that we must protect our expansive views from distracting elements. And that's exactly what needs to be done in respect of the area I wish to speak about, which is called Rhiat Shells. That in English is Charlie's View. This is an area of land which my family decided to adopt to make a memorial site for my parents, my father being Sir Charles Carouche and my mother Margaret Carouche. We are fortunate in that our family farmland, which looks over the Irish Sea from the east coast in Maccled, commands wonderful views over Maccled Lighthouse and the Irish Sea towards England. The area that we chose to develop as a memorial site also has views over Scotland and to Wales because it is sited higher up on our land. It's very common to see the English and Scottish coastlines, sometimes with spectacular clarity, although Wales is a little more elusive. Regarding the clarity, I'd like to draw your attention to the fact I was brought up on our family farm, and it was quite common to see Windscale, the nuclear power plant, now called Sellafield, and you could quite readily see their cooling towers. On a very clear day, you could see the steam rising from their cooling towers. So seeing across the whole of the Irish Sea is not an unusual thing. Another point of living in this wonderful area that I was brought in was seeing the sun and moon rises. We talked earlier, I think, about seeing the dark skies from above, but in fact, a great deal of the beauty associated with dark skies comes from moon rises, which are very spectacular on the east coast. And as well as seeing the far coastlines, we can, of course, see the activity over the land that runs down to the sea and the sea itself. We can, from Rhiat Shells, watch bird life, and we can see the dolphins and the seals quite frequently. Shipping, fishing boats and pleasure craft are also of interest if you're standing there. The constant changing of the sea and the sky make the place infinitely interesting and always beautiful. Across the road from the main part of the site is a viewing place in memory of my mother. This looks inland towards the Brule Ridge and Snaefell, and lower down to Ballaglass Glen. Again, this is a magical view. And as the point has been made earlier, although it faces inland, it is of course embraced by the sea of the Irish Sea, which enhances its beauty. The point earlier being that it's very difficult to separate inshore views and the sea views. Our family has been blessed in that our land there borders on the Neolithic site Balafale Cairn. It's a burial ground established about 5,000 years ago. It is the northernmost of 3 similar sites, one being Cashlanard, which is very well known, and that it is in line of sight of Balafale Cairn. We believe that these sites have great spiritual significance, and they are definitely very atmospheric sites today. To add to the sense of spirituality, just across the lane that borders Balafale Cairn is the Quaker burial ground. This is a deeply spiritual and very tranquil place. So I hope I've given you some idea of a sense of how special this area is, and I do hope you will visit it. Since we've completed it and invited the public to enjoy it, we've had many visitors, including professional photographers and dark sky enthusiasts. In fact, the Dark Sky organisation asked if we could make it a dark sky site, but we didn't want to do that in case we became liable for any accidents, because there is a steep drop in one aspect of the area. The proposed turbines would destroy the sea views and the night sky on the horizon. They would simply block our sea views totally. They would destroy the marine life, the drilling into the seabed and pouring tons and tons of concrete, which will never be removed, will drive away what it doesn't kill. And it will destroy much of the bird life. And, very sadly, the tranquility and spirituality of this precious place, because the turbines are effectively an industrial site. It's quite possible that by now you've heard the quotation from our national poet T.E. Brown's poem, Folkstal Yarns, many times, because they're very apt to this whole proposal. He speaks of, with loving feet to trace each hill and glen, and find the ore that is not for the mart of commerce. This area should never be sacrificed to the mart of commerce. Thank you.
Thank you very much. And we will be looking at those sites on some of our unaccompanied basis. So thank you very much. And if you wouldn't mind just making sure that, and I'm sure Mr. Randa will have the locations, but in the post-hearing summary, if you'd send through the absolute locations so we ensure we see it. Thank you. And then let me turn to the person. Okay, thank you. If I can just move down the bench, thank you.
Thank you. I'm Martin Cubman. I live in Portyvollen, presently an idyllic village on the Mackle coast. It's my contention that if there were meaningful, independent visual impact information and meaningful cost-benefit analysis available to the examining body and to the Manx people, it would make your decision much, much easier. I think it would be a straightforward one. And if I can expand on that, with regard to visual impact, I mean, as we've already heard, really, a key differentiator of the reason why people visit the Isle of Man, why people live here, and why new residents come to the Isle of Man, is it's an area of outstanding natural beauty with beautiful land and seascapes. To put up 300-metre high windmills 6 miles from the shoreline would absolutely devastate that view of the Isle of Man, and there are material costs associated with that. They would unfold in the short term, but be with us forever. The benefits, in so much as they've been described in any depth, are subjective and for the very long term, and principally accrue to the shareholders of Ørsted and the people of the UK, not the Isle of Man. If I could make a more minor point about the visual impact, a lot has been talked about the impact on those on the coastline, and of course that's very obvious. But there are 25 fells over 1,000 feet on the Isle of Man. They're dotted all over the island, although principally in the north, and I've climbed all of them. From 20 of them, you will be able to see these windmills. So it's not just the people who are walking the coastal path or driving along the coastal roads. It will be anyone who tramps the fells of the Isle of Man, and that's a lot of people. So thank you for listening, and I'll let me pass it back.
Thank you. Miss Newton, I think you actually had your hand up as well.
Thank you. Did I understand that you wanted to take the question about impacts on ferry passengers, etc., by written question rather than comment at the moment?
Written question. So we have senior representation, and we have also read DEFRA's response at deadline 3 in relation to ferry passengers and the sense of arrival and departure, and the questions that we will be asking will be picking up those very points.
Thank you. The only other point I would make is, again, the applicant has made the comment to the effect that it doesn't think that you should do a journey from Heysham to Douglas, because this would take up too much time as an unaccompanied site visit and take up a whole day's time. I would just point out that I asked you to think about doing the journey from Heysham to Douglas one way. I didn't ask for it to be an accompanied site visit. And I think it's absolutely essential that you should be seeing existing turbines at Walney and Dudden Sands for what they are, so that you have some idea of the comparison that is proposed here with turbines 2 to 3 times higher. And I think it's rather remiss of the applicants to suggest that you shouldn't bother doing that. Thank you.
Yes, thank you. And you'll have heard my earlier comments in relation to the different viewpoints and places to visit where we haven't decided fully what we're doing, but we will certainly be taking all those representations on board. And then, Mr. Hainsham, I think you were just hoping to sneak in there. And then we're going to turn to the applicant for any comments, and then we're going to move on to the landscape enhancement scheme.
Yes, so as an addition, if you did have the time to take on a few extra little visits here and there unaccompanied, I would definitely recommend Clayhead Road. The very end of Clayhead Road, there is a bench and a viewing point in the Ballinet Trust land, a trust that's committed to preserving the natural beauty in the coastal area of Garth. And to sit there on a fine day and look north is truly spectacular and really evokes a sense of our independence and separateness. And yesterday you asked at the public meeting a lady what she felt when you were arriving on the Isle of Man, how they felt about that, and she couldn't answer, unfortunately. I felt I could answer for her, and that my answer would be that it's a sense of separateness. It's a sense of your home. This is your own home, and we're separate from the UK by our island surroundings and our sea surrounding, and this industrial installation would really pretty much destroy that. So I'd just like to add that all these little points to look at and from, such as Clayhead, are well worth a look, because it does really enhance that feeling of an island nation. Thank you.
Yes, thank you. And I think that if any of you have just raised points that you haven't already submitted, and I think we've seen quite a few of these, and please do submit them after the hearing. But I think we may also have been to that last location that you mentioned, Mr. Incham. Okay, the applicant. Yeah, so we did. But we have plenty more places to go and see, so that's not to say that we're not continuing. Ms. Sterling, did you want to make any more comments?
Amy Sterling, on behalf of the applicant, just a couple of points I've noted really for the record. Madam, first of all, we would reject the comments that were made about the impact of the proposed development on the ecological environment and the comments made around wildlife, etc. That's not supported by evidence or assessment. The applicant has carried out a very detailed environmental impact assessment, and of course, much of the hearing tomorrow will be to test that evidence. The other point that I would like to make is there was a comment made from members of the audience that this project would be forever. The operational lifetime of the scheme is 35 years, so that is also not correct. There was also mention of the cost-benefit analysis. Just again, for the record, the Isle of Man government has identified that there would be an economic benefit to the Isle of Man, and that the figure of 2 billion is within the realistic range of values, and that information again is before the examination.
Okay, thank you. All right. Now I'm going to turn to item 5, please. Is it?
Wait for the microphone.
You would need to wait the right microphone. Was it specifically about the point?
It's about the point that the lady just made, that the government have said the £2 billion estimate is realistic. Could you just check that? Because I don't think that has ever been widely available.
Madam, could you introduce yourself, please? So just for the record.
Oh, sorry, Julia Cragine, just a Laxey resident.
Thank you very much for that comment. We actually covered this quite a lot at the public meeting yesterday, and the matter is in examination at the moment. So you will see in a lot of the written questions, we're seeking evidence, and indeed at SA87 on Thursday, we'll be looking into this matter as well.
Amy Sterling on behalf of the applicant. I'm sorry to drag this out much further. Just to confirm that that statement is in the examination library. It has been submitted by the Isle of Man Government Economic Treasury. It is we won't call them relevant representations, but it is a consultation response that is before the examination.
I believe it's PCR 110, is that correct?
Amy Sterling on behalf of the applicant. Yes, that's correct. Thank you.
Okay, let's turn now to item 5. Sorry, I'm completely wrong. Item 4H. And for those just leaving, thank you for coming today. Your contributions have been helpful, and we will be listening and thinking about the evidence you've given us, so thank you to those that are leaving. So item 4H, the applicant, and we're looking for an update on the proposed landscape enhancement scheme, including the parties that have been consulted, likely timescales, and how it proposes to secure the scheme. Ms. Sterling.
Dr. Kieran on behalf of the applicant. In response to the examining body's first written questions, we responded to question 1.7.3.1a to say that we would explore enhancement measures. Just in relation to that, and just in very brief summary, we say the compensation of seascape and visual impacts cannot practically be applied across areas impacted outside the order limits. We went away and we looked at what had been done, what precedent in relation to other offshore wind farms and similar developments that had secured landscape enhancement funds. The most applicable ones really would be Rampion 2, Mona and Orwelly Mooir that had secured landscape enhancement funds to compensate for effects upon national parks, areas of outstanding natural beauty or heritage coasts, and those designations are designations that we don't really have on the Isle of Man. So in looking at that, we basically we don't see that there's direct applicability for an enhancement fund for those features. We don't have that level of feature on the Isle of Man. I know that's still an area that needs some clarification in terms of the policy and whether it's a national, regional or local scale, but our first reading of that is that it wouldn't be directly applicable for the enhancement fund, but we will keep that under review. We're open to the idea of discussing enhancement funds, and we'll discuss with DEFA, and we'll pick that up in our statement of common ground with them, but that's just our position at the moment in relation to enhancement funds and their applicability to the project.
Can I just put something into your minds in considering that, and that is the Espoo Convention and how you are responding to it? I don't want you to answer now, but I would like you to have a think about the implications of that and in relation to the landscape enhancement scheme. Please go on, Dr. Caroline.
The only other thing to say in relation to the landscape enhancement funds is both Sheringham Shoal and Dudgeon extensions and 5 estuaries were also other projects that we reviewed. There had been suggestions for landscape enhancement funds for both of those projects. For 5 estuaries is particularly important because the examining authority in that noted that the applicant had made significant pre-application mitigation in reducing the size of the array, the number of turbines and some of the technical parameters, and therefore had taken significant steps to mitigate, and there was no requirement then for a landscape enhancement fund. Our position will be broadly similar, and that approach that we have taken through our developable area approach that we have sought to mitigate where possible in the pre-application phase. So we think that's something that the examining body should consider or have due regard for as well. But again, we're happy to have discussions with DEFA, and will continue to do so through the Statement of Common Ground.
Sorry, Statement of Common Ground with who? It's DEFA.
DEFA.
It's getting late. Sorry if my concentration slipped slightly. DEFA, so I'm going to take a step back. You are proposing a landscape enhancement scheme. Then I misunderstood what was in your response.
Amy Sterling, on behalf of the applicant, the response was intended to signal that we were considering a landscape enhancement scheme. That remains the case. There is no commitment to deliver it, but we haven't ruled it out. The current work that is ongoing is identifying what, if anything, the landscape enhancement scheme could meaningfully provide, which actually relates to the proposed development. It wouldn't be compensation or mitigation because it wouldn't affect essentially the landscape assessment outcomes, and therefore it would be purely enhancement. Therefore, just providing a sum of money into Section 106 agreement, which is what many of the landscape enhancement funds have done to date, we're still considering how that might actually apply within the Isle of Man and what actually could usefully be done in terms of enhancement, rather than just sort of pot of money to be administered within a national park, because that statutory framework of a national park, and having someone who manages the special qualities, etc., doesn't replicate in the Isle of Man. So it's not a no, it's just in further consideration with DEFA, as Dr. Caroline referenced.
Okay, so then to help your hypothetical, it's not a no, and we will push you quite hard, I think, on this. Much the same way as we look at the MIC in a hypothetical context, we would very much like to understand what that landscape enhancement scheme might entail, accepting it's all without prejudice. Who might be the stakeholders that would discuss and be involved in it? What the likely measures might be that were included, how the scheme might be secured, and how you would propose to put something in place in the event that the examining body might want to include something about this in a recommendation. So taking the point that I've now heard, that would really assist us in taking this forward. What we don't want to do is find out that you're saying, no, we can't do it, or yes, we can, and it's too late for us to actually think about it in a wider context.
Amy Sterling, on behalf of the applicant, yes, that's all understood. We do have a draft landscape enhancement plan that we've been working on, so we can revisit that and consider what would be appropriate to include, probably on a without prejudice basis at the moment, to show essentially what our train of thought is.
Just a couple of clarifications. So, given that you've started thinking about this halfway through the examination, just explain to me that had this thinking between you and the government departments happened ahead of time, ahead of the examination, whether input from other parties, other principal stakeholders, would have indeed informed what this enhancement scheme includes.
Amy Sterling, on behalf of the applicant, I would essentially be speculating perhaps if the discussions had taken place earlier, some other people who are involved in the examination, such as Manx National Heritage, might be interested. They, of course, if we submit a draft at, say, deadline 4, which I think is our working deadline for all deliverables, they would have 5 subsequent deadlines to provide comments on that. I'm not sure I can say for sure who would have been involved in the discussions had they taken place prior to examination.
Okay, so I'm not persuaded by that response, Ms. Sterling. So I think, just think about that in the context of the 3 examples you've just given us, Awella Moore, I think, Mona and Rampion 2. Just think about that in that context and tell me what was the process that was followed with the compensation schemes that you've just compared yourselves to. Well, you've compared yourselves and found that you don't, that there isn't a comparison. But so just think about that in terms of the process that might have been followed in terms of engaging with parties. And then in that regard, I think it'll be helpful for the examining body also to understand what the implications are. Let's say you go away and you think about that and you're like, okay, actually engagement with some heritage groups and, other parties would have been imperative in coming up with this compensation scheme. Then how do we resolve that so late in the process? It would be helpful to have your thoughts on that. And your thoughts might be exactly what you've said right now, but I do want to put a marker down that in my head, this feels like it's coming up rather late in the process. And so we might be missing some very key steps in the process. Before you respond to that, I did have another question, if I can just remember it. Yes. Did I understand it correctly when you said that because you don't think that you are that level of designation as some of these other places, your compensation scheme, if you propose a compensation scheme, it will not be of a certain level or something like. Have I misunderstood that point?
Can I just explore that briefly, because I think we need to wind back the clock a little to that point where we set an action around a conversation to be held between Cabinet Office DEFRA and the applicant to consider which, if any, Isle of Man landscape policies and designations are, if we are working within the framework of the Energy Suite NPSs, and specifically EN1 paragraph 5.10.9 onwards, are, in inverted commas, national, in inverted commas, subnational, regional, and which are essentially outside nationally designated areas per EN1 paragraph 5.10.12, because that's essentially the sort of framework, the policy framework exercise that then conditions the conclusion about whether or not you might be in a place where a compensation scheme applies. Now, Dr. Carolyn, my immediate response to your proposition that one doesn't is that there's an initial view that there is nothing in the Manx legislative and policy framework in relation to landscapes that equates to the higher tiers that are identified in MPS EN1. But the challenge that we have placed to you is the proposition that as a essentially small unitary nation, the Isle of Man may not view things in quite that way. Part of the purpose of the conversation between yourselves and DEFRA is to overview the existing strategic plan, landscape policy and area plan provisions to try and resolve where they sit and whether they kind of provide a complete book, in inverted commas, for the purposes of addressing this question. And if they don't, and we are then in the land of MPS EN1, can we create a ready reckoner that frames Manx considerations, policies and designations in terms that are relevant within MPS EN1? Once we've done that exercise, then I think Ms. Sahai's question, and indeed the question that also proceeded from Ms. Fernandez, really then sits as a consequence out of that exercise, because if you conclude you have got national policies or tiers or designations in Manx terms, then the implication of the application of EN1 is you respond to them at the national level, and that invokes all of those components of EN1.
Amy Sterling, on behalf of the applicant, couple of points to come back on. The first is, points all well made, sir. I think I wasn't suggesting that the designations had a less value as a national parks. It was a practical observation that national parks within the UK have someone who manages them in accordance with very defined special qualities, and those enhancement funds that have been put forward, and they are enhancement, they're not compensation, they don't actually compensate for the impact, they do just provide enhancement, are managed in that context, which doesn't exist in the Isle of Man. There's no equivalent person who manages the particular area, so it's the practical application of the scheme rather than whether or not they're equivalent in terms of value of landscape. The other point that I would make is, just with respect, Madam, I would reject that we're so far through the examination. We're only had 3 deadlines. We've got 6 deadlines still to go. We're 2 months in. We've got 4 months left remaining of examination, including a full set of hearings left in July. From a brief review, it seems that Mona added this in at the very last deadline of the DCO examination. We're nowhere near that, that late in the day. So I would suggest there is ample time left in examination to consider an enhancement scheme if it's put forward at deadline 4.
I'm encouraged by your optimism, and I think that's fine. All I would say is I just want to re-emphasize the point that Mr. Smith's just made, is that because we're in the without prejudice region, I think if you were to assume that this is the highest level designation, what would the compensation scheme look like? Notwithstanding the point you've just made, which is a well-made point, but potentially taking that into account rather than not proposing a compensation scheme because of that, but rather the compensation scheme taking that limitation into account is something that I think we would really like to see. And an initial, as you've already mentioned, a statement of common ground with DEFA, so this being developed in consultation with DEFA seems absolutely fine, but do bear in mind the process that I've suggested, and in terms of the stakeholders, and particularly the statutory bodies and local authorities that might need to play a role in inputting into that.
And again, at risk of just prolonging this point, but just because you don't find the immediate analogue of an English or Welsh National Park Authority ready to take, I guess, carriage of an enhancement scheme, does not mean to say that A, there is no such body, and so there's probably a conversation to have with relevant Manx principal stakeholders about that question. And secondly, even if there is no such body, one of the remits that planning processes and creative proponents have is to think about whether one might need to be created if there is an underlying purpose and a need to be met. Then sometimes special purpose bodies can be framed to deliver outcomes that turn out to be necessary.
Amy Sterling, on behalf of the applicant, all the comments are understood and we'll reflect on them. Thank you.
Thank you for that. I'd like to turn to DEFA for a temperature check, thoughts, response, reaction to the discussion that you've just heard, and I'm not sure if it's yourselves or, and I'm actually looking at DOI, but I shouldn't be looking at DOI. DEFA, Mr. Milne.
Ken Milne here, representing DEFA. We welcome that discussion during the Statement of Common Ground, and we'll obviously involve our colleagues from Cabinet Office as well in those discussions, and other key stakeholders as required.
It does strike me that logic tells me there must be vehicles for managing these things, even though perhaps there's no national park or authority per se. So I'm sure there's a solution, if a solution is there to be found. Yeah, we were chewing over deadlines. It would be helpful to have a separate note on your thinking on the landscape enhancement scheme, please, for deadline 4. But DEFA, we would ask you to respond by deadline 5, which is as my colleague has mentioned, it's only a week after deadline 4. And what that tells me is that if both parties could talk beforehand, then there's no surprises in terms of what. And actually, I don't want to ask you to do a joint note because that's actually quite tiresome unless you're already at that point. But I think if you could talk to each other, then the applicant, if you can put something in at deadline 4, which DEFRA has already had sight of and is thinking about, then that makes the task of DEFRA coming back at deadline 5 slightly more realistic. Is it all right for both parties?
Yeah, that's fine.
Okay, I'm seeing 2 nods.
Yes, thank you.
Did DOI want to say anything on this? Mr. Garden? Anybody else on DOI? I don't know if Mr. Garden's still online, actually.
Robert Garden on behalf of the department, still here, still going strong. I don't think we do have anything to add at this stage. And in terms of our consideration, I think we will just consider how that could best be secured through the MIC if needed.
And Mr. Garden, in your experience, have you come across anything similar that perhaps the applicant hasn't responded to that might have a bearing and might assist the conversation between DEFRA and the applicant?
Robert Garden on behalf of the Department of Infrastructure. No, I think the relevant schemes that have been referred to by Ms. Sterling are correct in terms of DCOs having dealt with this and the way that's been put to you so far. So nothing else to add from our perspective.
Okay, thank you.
Thank you.
So I am going to turn to item 5, but before I do that, there's one other matter which I would be grateful for the applicant to look at, and that is in relation to projects with a similar scale of magnitude and effects. And you have provided some comparative data, I'm referring to, from recollection, Hornsey 4 and Mona, and the third one eludes me. Maybe, but what would be really helpful is if you would look at a comparison, something along the lines of a document submitted into East Anglia 2 in response to issue-specific hearing 8. And that document compared East Anglia 2 with Rampion and Navitas Bay. So not Rampion, the second one, but the first Rampion. I would ask that you have a look at that or any other document that's very similar and provide a comparison, because I don't think we've seen that sort of comparison. Dr. Carolyn?
Could you just clarify a comparison of what exactly? What are we comparing?
There are different parameters, and I have a paper copy here, so I'm just looking at it. It talks about, for example, distance from the AOMB and Heritage Coast, turbine height, number of turbines, geographical relationship with designated landscapes, and so forth. But if you look at this, then it's presented in tabular format, and it would be helpful for us. And if it is in different parts of the application already, then that's great. Bring it together into one piece, please.
Amy Sterling on behalf of the applicant. Understood, madam. We'll review the document that you've referenced and look to provide something similar. Thank you.
That's great, thank you. Okay, so just changing direction ever so slightly, we're looking at landfall and coastal processes, and quite a large part of this item we are going to put into written questions. Nonetheless, the examining body has an overriding concern that the core construction documents outlined in the Code of Construction Practice, the design and layout plans, currently provide what infrastructure may be constructed, but provide very limited detail on how the landfall would actually be constructed in practice. And the scope of works within the outline Code of Construction Practice is blank, and the outline design and layout plan largely defers substantive matters to post-consent approval. And so we're not sure that we are able to understand the actual construction approach that has formed the basis of the EIA and the assessed worst case. Would you mind please taking us through the construction sequence and the techniques that would be used? And DOI, I would be interested in any comments that you may have as in response to what the applicant sets out.
Toby Yates on behalf of the applicant. Good afternoon. By way of reminder, I'm an associate at Pinson Masons, legal advisors for the applicant. So just to come back on the initial point for the explanation as to how the works are going to be carried out, this was touched on at specific issue hearing 2, and from the list of documents referred to agenda item 5A, that just misses out a couple that might be useful to point the AXB in the direction of. So you've got the indicative layouts, which is HS1-006, and then the indicative master plans, which is D1-067. They came up in the context of both Groudle Bay and Portskillion specific issue hearing 2. Obviously now it's only relevant insofar as Groudle Bay, and both of those documents touch on the works and how those works are going to be carried out for both Groudle Bay Beach and Groudle Bay Field. That's all the information that the applicant would intend on putting forward at this stage. Just to add in terms of the distinction of what's being carried out versus how that's being carried out, obviously how works are being carried out is descriptive and explains from a more technical perspective, and those documents will hopefully satisfy you there. What the Code of Construction Practice looks to do is then secure what parameters are then actually going to be delivered in accordance with that approach and methodology, and that's what's secured in the outline Code of Construction Practice and Requirement 29 in the draft MIC.
And so without having that document fully in my mind, would that be similar to a construction method statement that we have seen on so many other DCOs, or is it something different?
Amy Sterling on behalf of the applicant. That document sets out a sequencing essentially of the works. It's not a method statement. The applicant has reviewed the landfall construction method statement across various different projects in advance of this hearing. Whilst it considers that that information is before the examination, it does recognise that it's in probably a few different places, and it could see the utility of bringing it together in a single landfall construction method statement. So we'd be happy to provide that, Madam.
Ms. Sterling, that's helpful. And that master plan is, you're right, it is not mentioned in this list, but was a part of our consideration. So D1067, it was a part of our consideration, and I think it kind of exacerbated some of our thinking because it once again, like your hearing submission, tells us what's going to happen, the sequence of what's going to happen, but potentially not necessarily how you're securing some of the techniques that you've talked about. So what would be helpful for us is to understand what you intend to put in the scope of works in the Code of Construction Practice.
Apologies, Madam, can you repeat your question? I had some...
the question is that what you intend to put in the scope of works in the Code of Construction Practice, I believe that's Appendix B, and why there isn't a landfall method statement included. And then a follow-up question would be, how would some of these techniques be then secured in the draft MIC? So we've mentioned the absence of a schedule of trenchless techniques, but that's only a part of our wider concern that some of these methods of construction, we don't seem to be able to track them from the Code of Construction Practice to your commitments register to the draft MIC.
Dr. Carroll on behalf of the applicant. In relation to the landfall construction method statement, so we reviewed a number of these East Anglia 1 North Mona transmission assets, Morgan and Markham transmission assets, and Inch Cape offshore wind farm, which are all of varying quality and degree of usefulness really, but they typically contain 4 sections: roles and responsibilities, which is covered in our Code of Construction Practice; 2, surveys, which again is covered in our Code of Construction Practice. The Part 3 will be the landfall construction techniques, which we have set out either in the project description or in the indicative layout. And Part 4, which would be monitoring and remedial action, so that would be for drill failure and bentonite breakout and things like that. And that also will be set out in our Code of Construction Practice. So while they are in disparate locations, we feel that in the whole they're all there. We could pull them together into that coherent landfall methodology and have it as an annex to the Code of Construction Practice, so it just brings it all together in one place. That's possible. And then all of those are secured. I mean, the only onshore parameters that are secured through the MIC are at the minute, I'm not sure, I don't think there's any. So we could propose to put some onshore parameters. So the transition joint bay, the total area for temporary works, the construction compounds, so that type of material or that type of constraint we can put on the MIC. All working practices and all techniques are secured through the discharge of the relevant plan by DOI pre-construction.
Just because the management plan is a certified document, you believe that that is secured
Sufficient.
through the draft MIC. I remain slightly unconvinced about that, but let us take that away and process that, because there are some techniques which I believe are better secured through an exact provision in the draft MIC rather than the Code of Construction Practice or the outline Code of Construction Practice, because ultimately you do have the ability to change the outline Code of Construction Practice. So some areas where the adverse effects of that particular construction technique is something that needs to be controlled, I think the examining body would like to see those secured in the draft MIC itself. And we're going to we've covered this in written questions with respect to requirement 21, where, you've given a response to the question, but we remain slightly unconvinced about it. But so that's one point. But just going back to your earlier point about the fact that some of these points are already in the Code of Construction Practice, if I heard it correctly, that some of these areas you are going to put them in the Code of Construction Practice, they're not already there.
Amy Sterling on behalf of the applicant. Yes, in summary, I think not every DCO application or offshore wind farm application has a landfall construction method statement. The applicant's portfolio
Fair
projects
point.
haven't had one. It's been raised by the examining body. We've reviewed some examples, found we can see a usefulness in pulling together different information into a single coherent point of reference. Dr. Caroline was proposing that we include that as an appendix to the outline Code of Construction Practice, which is secured via requirement. It's a certified document. It's secured via requirement. The applicant will have to discharge that requirement. So the method statement would be secured in that manner. Dr. Caroline also made the point that we reviewed the design parameters, which were specifically secured for the landfall works, and noted that they were I think there is only one, though it's a maximum of 2 cables, and identified some additional design parameters that we could specify on the face of the MIC, for example, maximum construction footprint, for example. So it's a sort of a hybrid solution we're proposing. What I did want to mention at this hearing is we went clear in our preparation what a schedule of trenchless techniques would be, and if that was something specifically that you would be looking to secure within the MIC, or what the form or content of it would be. So we would welcome further direction from the examining body on that, so that we can consider if that's something we can provide, and happy to take that now or indeed in a written question, which I know are coming soon.
Gosh, there's a lot to unpack there. Just in terms of the schedule of trenchless techniques.
I think we'll put that into writing.
Yeah, let's put that into writing. Okay, sorry.
Ms. Pownall would just like to come in, so I'm just going to invite her in.
I think the Chair's right. There's a lot to unpack there, and it's all really helpful. I think all really helpful information. I don't know about the Chair, but I would welcome lifting the descriptive bits out of the project description into an appendix to the COCP, which is, I think, what you're suggesting. Is that right?
Amy Stilling on behalf of the applicant. Yes, in part, not the whole project
the whole
description,
thing,
but
the unpacking.
there's some design parameters described within the project description.
Okay.
Yes,
I just wanted to confirm. Thanks.
I'm happy to close that, Ms. Fernandez, but the point about matters being secured because they are in the outline code of construction practice in the appendix. I just want to keep the powder dry on that one, because that is something that, you know, there are certain aspects of those triggers and controls which I feel are better secured through a requirement in the MIC. But generally, the point about a method statement, what it includes, is something that we're generally agreed on, and that can be in action.
Well, we're coming back to the MIC on Thursday, so we can always pick it up again. So I'd like, Dr. Carolan, did you wave because you wanted to just come in?
Dr. Carolan, on behalf of the applicant, I'm just looking at the track change version of the Code of Construction Practice, which was submitted at deadline 3. And within section 8 of that, there's scope of works section. So 8.2 is construction works, and 8.3 is construction method statements. So we would propose to just elaborate on the content of that construction method statement at section 8.3 and to provide the detail that you want. And then we just need clarification on what your intention is on the schedule of HDD works or the schedule of trenches techniques, and we can include that within that.
Okay, so I'm going to just ask DOI for your thinking, given very much that you would be responsible for the discharge of this requirement. So have you been discussing this with the applicant? Any comments and feedback? Mr. Garden.
Yeah, Mr. Garden, on behalf of the Department of Infrastructure. I think the applicant has trailed where we were going to go with this, which is effectively matters that are dealt with through more detail in relation to the Code of Construction Practice and the method statement. And I think to the point that's just been discussed as to how best this sit, there is potentially a difference between where there's an absolute commitment to a methodology where that may sit best through a requirement versus where there's flexibility sought in relation to the method of installation, where that may be best secured through a method statement with more detail around the methods involved with that. For instance, if there's flexibility for open cut or trenchless, that may be best dealt with through a method statement, but we're happy to work with the applicant on that.
Yep, that's a point well made. And just as I've got you there now, there was a DOI submission at deadline 3, D3028. That set out that DOI had continued concerns in respect of aspects of construction, in particular the access plan and the works access strategy document. I wonder if you might just explain these a little bit further, and how near or how far you are in terms of reaching a way forward with the applicant.
Yeah, Robert Garden on behalf of the Department of Infrastructure. I think discussions are ongoing with the highways team. I don't have my highways colleague with me today to provide an update on that. So if you're okay, we will provide that update at either tomorrow or at the next deadline.
So your DOI colleagues in the room, are you able to add anything further on this particular matter?
Emma Rowan. Is it on? Is that on? No? Okay. It is on. Well, Emma Rowan for the Department of Infrastructure. We can't add anything other than what Mr. Garden said at the minute, but we will try and endeavour to get in touch with our highways colleagues. I know that was our position as of deadline 3, so I haven't had anything further, but I will check and we can confirm at deadline 4 in writing. Thank you.
Yeah. Okay, then it doesn't sound like I can go much further on that one now. Thank you. Thank you, Mr. Garden.
I just, before Mr. Garden leaves the virtual room, just really quickly, I think your point about flexibility is well made, and I wonder if that input can be provided to us real time, so not necessarily after the applicant has in fact submitted the method statement. So the reason I'm asking for that is because we're just very well aware that deadline 4 is a good almost a month away from right now, and the reason that there was such a big gap was to account for the national holidays on the island. So If there can be some movement, some conversation between yourselves and DRI so that there's a certain, there's agreement, it's agreed in the statement of common ground, or at least en route to being agreed in the statement of common ground, both in terms of content, but also in terms of what you expect should be secured in the MIC and what should not be secured in the MIC. It'd be really helpful to have that clarity from both parties by deadline 4, if that's possible. Yes? No?
Yeah, Robert Garden on behalf of the Department of Infrastructure. I'm absolutely happy to work to that time frame.
Okay, thank you.
Amy Sterling on behalf of the applicant, likewise.
Thank you, that's good. And then just a quick question on 5D for DEFA. Again, at deadline 3, you responded to the noise validation survey, which the applicant submitted at deadline 2, and you had concerns that had not been addressed by the applicant's submission. Do you recall what those concerns are? And again, I'm trying to take a sense of, are you far apart in that conversation, or are they I'm just trying to, minor concerns? Mr. Milne.
Ken Milne, representing DEFA. I can't remember what those concerns were, I'm afraid. It wasn't any of the major ones for us, but yes, we'll come back and we'll review that one and come back to you, that's okay.
Okay, the fact is you have responded at deadline 3, and applicant, I'm sure you will reply at deadline 4. I was just thinking as you were both in the room, I could ask you to have that conversation, but a response at deadline 4 is fine. Unless the applicant, you're going to say something different now.
Dr. Keoghan, on behalf of the applicant, as far as we were aware, that DEFA were broadly happy with the noise validation survey. That's my understanding. If there's other comments that I've missed, then I will take them up with my onshore colleague and pick them up with DEFA as soon as possible.
There was definitely something I read at deadline 3 from DEFA on it.
Excuse me, Ken Milne, representing DEFA, can maybe come in there? I've just been reminding my colleagues, it was the working hours for the directional drilling was our concern, whether it was a 24-hour or just a daylight working. And it's certainly something we'll work through their statement of common ground with the applicant. Thank you.
Dr. Keoghan, on behalf of the applicant, we can easily pick that up in the method statements in the Code of Construction Practice. I think the issue with the noise is probably, I understand, so it's the noise validation and the noise assessment for the cable pulling. So that is, for us, we internally we think that's a really easy issue to be resolved, and we'll pick it up with DEFA.
That's what I want to hear, thank you. Okay, at this point I'm going to hand back. Applicant, is there anything further you want to say? I'm going to hand back to my colleague, Ms. Sahai.
And to break the pregnant silence, there are a lot of documents obviously in play, and Ms. Sahai is just making sure that everything that needs to be addressed has been.
Thank you very much. By some miracle, we've actually made up for lost time, and we have, are about to finish in time. I think as we decided for yesterday, hearing actions will be issued as soon as practicable after the close of all the hearings. And at the moment, the intention is to issue them by the end of this week. As such, we are not intending to summarise the actions after each hearing, so we're not going to summarise them today unless anybody is unclear about any actions. I don't see anybody raising any questions, so that point is clarified. All actions, unless otherwise specified, are expected at deadline 4, which is the 16th of May, 16th of June.
16th of May.
And
I think you nearly caused a conniption at that point.
But And yeah, unless there are any further questions, and I'm just looking around the room, there aren't. It's 5:20 and I can close specific issue hearing 5. Thank you very much for your contributions.